Acting Deputy Chief Justice, with your leave, can I ask the Registrar Clerk to call the case, please?
Yes, you may.
Good morning, Acting Deputy Chief Justice and Justices of the Constitutional Court. My name is Ntokozo Kwabe, and I am the Registrar Clerk for this hearing. All counsel are online. I call the matter of Minister of Finance and Afribusiness NPC and others for hearing.
Acting Deputy Chief Justice and Justices of the Court, I appear together with my learned friend, Mr. Stubbs, for the applicant.
Thank you, Mr. Maineche.
Acting Deputy Chief Justice and other justices of the Constitutional Court, I appear on behalf of the respondent with Mr. Marebe.
Thank you, Mr. Bergentine.
Acting Deputy Chief Justice and Justice of the Constitutional Court, I appear on behalf of the Rule of Law Project for the first amicus curiae.
Thank you, Mr. Oppenheimer.
Acting DCJ, Justices of the Constitutional Court, I appear on behalf of the Economic Freedom Fighters, the second amicus.
Thank you, Mr. Kasiboto.
Deputy Chief Justice and other Justices of the Constitutional Court, I appear on behalf of the intervening party.
Thank you, Mr.
With my learned friend, Ms. van der Walt. My pleasure.
Thank you, Mr. Van Zyl. Mr. Maineche.
As the court pleases, I will, in the time allocated, deal with the main appeal and the application, the main application, and my learned friend, Mr. Stubbs, will deal with the intervention application. In the main application, there's only one issue before this court, and this is whether the minister acted ultra vires in making regulations 3B, 4, and 9, which the SCA held to be unlawful. And the SCA judgment in that regard is at paragraph 40. We say it's also clear from the Afribusiness answering affidavit to the application for leave to appeal that there is only one issue. They say so at paragraph 2.4 in volume 10 at page 962. They say, I will restrict the opposition on behalf of respondent in the present application to the determination by the SCA relating to the ultra vires promulgation of the 2017 regulations by the minister. And just turning to the regulations which were declared invalid, that's 3B, that grants discretion to organs of state to determine whether pre-qualification criteria will be applicable to a tender. And that's at volume 1 at page 34. And regulation 4 stipulates the pre-qualification criteria that may be applied where organs of state exercise their discretion to apply such criteria. And that is also at page 34 of volume 1. And regulation 9 provides for subcontracting and provides to whom organs of state may stipulate that contracts be subcontracted where it is feasible. And the purpose of the regulations which have been declared invalid is to prescribe qualification criteria, as I've indicated, that organs of state may in their discretion apply in order to determine or qualify what would be acceptable tenders and also for purposes of subcontracting. In relation to the jurisdiction of this court, we submit that the issue of the minister's powers engages the jurisdiction of this court because it raises a constitutional issue, and that we refer to the judgment of the SCA, in this case at paragraph 42 in volume 9 at page 930, where quoting the judgment of this court in Newclicks says a finding that the minister acted ultra vires is in effect a finding that the minister acted in a manner that is inconsistent with the Constitution and his conduct is invalid. So that issue squarely raises a constitutional issue. And We also submit that it would be in the interest of justice in this case to grant leave to appeal, one, because there are prospects of success in the appeal, and secondly, it is in the public interest to provide clarity as to the minister's powers under the Framework Act. I'll call the PPPFA the Framework Act. The first issue I want to address is why we submit that the pre-qualification criteria are valid. The first point to note is that the delegation of powers to the minister under Section 5(1) of the Framework Act is not under attack. And the court will recall that that is the power that the minister exercised, the power to make regulation under Section 5(1). So it can therefore be accepted that Parliament validly delegated subordinate legislative power to the minister in terms of Section 5(1). And the only question is whether the regulations fall within the delegated powers to the minister under Section 5(1). And the determination of that question turns on, firstly, the language, context, and purpose of Section 5(1), and consistency of the regulations with the Constitution and the Framework Act. We accept that if, to the extent that the regulations breach the Constitution or breach the Framework Act, they would fall outside of his powers under Section 5(1). But we will submit that, in fact, the regulations fall within those powers. The first point we address is the language of Section 5(1), because as this court has said and the SCA has said, the language actually used in a provision is the point of departure for purposes of interpretation. And we say that the language that is used in Section 5(1) provides broad discretion to the minister. The regulation provides that the minister may make regulations regarding any matter that may be necessary or expedient to prescribe in order to achieve the objects of this act. And so we submit that first, it's clear from that section that the choice of method is left to the minister as to what method tool is to be used by way of regulation to achieve the objects of the act under that section is left to the minister. And the words necessary or expedient confer on the minister very wide discretion. You'll recall the SCA rejected the submission on the basis that we had relied on the judgments of Oma and Momoniat, which were decided in the context of the state of emergency under apartheid. And the suggestion by the court, or the finding by the SCA, was that that context supported the expansive interpretation, but that our context is a different one. We submit that the SCA erred in that regard, and we have referred in our heads of argument to two judgments which support our submission that this kind of phraseology confers very wide powers and wide discretion on the minister. The first is a judgment of the SCA, which is MEC, Department of Education, Northwest Province versus FEDSAS. And it is a judgment we have referred to in our heads of argument at page 12 at paragraph 25. That judgment concerned the power of the MEC in relation to making regulations that would regulate schooling, but in addition, in relation to hostel accommodation in schools, in advance of the right to basic education. And the power that was conferred to the minister in that the relevant act was also framed in very wide terms like the current power. And the court will find the relevant section 27(1) of the Northwest Schools Act at paragraph 14 of that judgment. And the section says the MEC of the council, the member of the council, in consultation with the head of department, may make regulations which are not inconsistent with any law as to A, any matter which shall or may be prescribed by regulation under this act, and B, any matter which the member of the executive council may deem necessary or expedient to prescribe in order to achieve the objectives of this act. And the SCA said of that power at paragraph 20, that the regulation making power in section 27(1) of the Northwest Schools Act extends to what the minister deems necessary or expedient to prescribe in order to achieve the objects of this act. This phrase, as submitted by the appellant, confers power of the widest possible character and leaves it to the decision maker to decide what method to follow in order to achieve the purpose stated in the subsection. And that judgment also refers to the Catholic Bishops Publishing Company versus State President and Another, 1990, Volume 1, SA 849. So the SCA itself has previously accepted that kind of power is of a widest possible kind. And what the SCA said supported a broad interpretation of that power in that judgment was that it was concerned with the right to education. So because Section 39(2) requires you to adopt an interpretation that better promotes rights, protect and promote rights, that was an interpretation to be adopted, and not to limit the MEC's powers to simply regulating what would be academic activities at the school, but also regulating hostel accommodation, because that is part of delivering access to basic education. The second judgment we have referred to is a judgment of this court in Municipal Employees Pension Fund, where the main judgment was written by Justice Mkandla, and there's a dissenting judgment by Justice Jafta, dissenting only in the sense of adopting a different interpretation to the interpretation of the wide scope of the power granted there. In Municipal Employees Pension Fund, the issue also turned around the breadth of the power that was given to the MEC. And in paragraph 33, after referring to the section in the ordinance which conferred the power, this court says in paragraph 33, the power given to the MEC under section 4 is indeed very wide. It includes the power to make regulations, providing for matters considered necessary or expedient for purposes of the fund. That power is not limited to items listed in section 4. Section 4C permits the MEC to make regulations determining which employees of local authorities shall be eligible for membership of the fund. The regulations are related to the fund's purpose or that of the empowering legislation. So also confirming that the power is indeed wide. And if I can just refer to what Justice Jafta had to say about that construction, where you have a list in the ordinance of various purposes for which regulations may be made, and then in the end you have that wide provision. Justice Jafta said in paragraph 80, this is the backdrop after looking at the various sub-paragraphs or subsections of that ordinance. This is the backdrop against which section 410 must be understood. The provision was meant to enable the MEC to regulate matters that are reasonably necessary or expedient to join the retirement fund. I'm reading the wrong place. The provision was meant to enable the MEC to regulate matters that are reasonably necessary or expedient to the proper operation of the retirement fund, whose purpose was to provide pension benefits to employees who could not join the superannuation fund. But those matters are limited to issues that are reasonably incidental to those specified in paragraph A up to N of section 4.1. In other words, section 410 does not create a category of matters that are separate from and independent of those listed in this paragraph. So Justice Jafta preferred an interpretation of the broad power by reference to the enumerated powers. We submit that even if one were to adopt that approach, in this case, you still reach the conclusion that the power under section 5.1 is a broad one, because it is unlike the power dealt with in the case I just referred. This power is not limited by an enumeration of other purposes that precede it. So it is standing by itself, and it is given in broad terms that it is there to assist the achievement of the purposes of the Act.
Mr. Maineche, your protection time has expired.
As the court pleases. And the other important feature of the power given, which shows its breadth, is the fact that it is to give
Mr.
effect
Manager,
as a,
Mr. Manager, can
Yes.
I ask something? And please tell me if you intend dealing with it later, because I interrupted you.
Yes, Justice Chitli.
Should the minister, in exercising delegated powers which you submitted, he has, ensure that he complies with the Framework Act and the Constitution?
Yes, yes, we accept that. So we do accept that if he exercises his powers in a manner that is inconsistent with the Constitution or the Framework Act, that would be ultra vires. And I will address those. I'll address the Constitution and address the Framework Act to show that the regulations are consistent with both.
So when you address it, please, if you can, just cover these two concerns that I have. Regarding the Framework Act, my concern is this: does the Framework Act envisages that when the minister makes a regulation, it makes a regulation that excludes upfront prospective tenderers? Or does Section 2 of the Framework Act envisages that groups or companies or entities would tender and then sets out a mechanism within which the objectives of transformation and broad-based economic empowerment would be met? So I don't know if I'm clear. Does it empower the minister to make a regulation that says upfront, well, you don't even have to come, or you are excluded upfront? Or does it say all of you can come, but but there is a mechanism within which the parties who had been previously disadvantaged can get additional points when they tender? My second question is this, and this one concerns the provisions of the Constitution, and it's about competitiveness. Whether if a minister makes a regulation such as Regulation 4, whether that element of competitiveness has been embraced.
So sorry, Justice, I just left my Constitution in the bag, so I wanted to get it out. Yes, I will address both of those questions. If I can just...
I'm referring to 217 specifically.
Yes, I understand, Justice Chitu. If I could just complete on the language before I move to the questions raised. The language of the section is to give effect to the objects of the Act, and one would go back to the section, to the legislation, to see what its objects are. And those objects are set out in the long title to the Act, which is to give effect to Section 2173 of the Constitution by providing a framework for the implementation of procurement policy contemplated in Section 2172 of the Constitution, and to provide for matters connected therewith. So the minister, and in terms of the regulations, can we provide any further detail to the framework, because that's what he is empowered to do, or to provide matters that are connected with the framework, which is set up by the Framework Act. And it's important here to just emphasize that the power that the minister is given to make regulations is not limited to achieving the objects of Section 2 of the Framework Act, but is to achieve the objects of the Act as a whole. So when one looks at the question of consistency, we would submit one must test the regulations as against the Act as a whole. And I will come to the question that is raised by Justice Chitli in that particular context. And
Mr. Manager, excuse me, Mr. Manager. Section 2172 of the Act, I'm dealing with the objects of the Act. of the Constitution says it provides for categories of preference in the allocation of contracts and the protection or advancement of persons or categories of persons disadvantaged by unfair discrimination. Does the regulations as they stand provide for that? Where
Yes.
Regulation 4 and 7 specifically refer to Black persons and not the broader group of persons?
Yes, it does, because the previously disadvantaged individuals include Black people. And this court has previously accepted that when one applies Section 9(2) of the Constitution, for example, one does have to recognize that they are, although previously disadvantaged people as a group suffered under apartheid, there is a recognition that there are degrees of disadvantage that people have suffered, and that that restitutionary measures are permissible where they target particular subsets of those groups. And we referred in our heads to the judgment of this court in Barnard, where the point is made by the former DCJ on behalf of the court, and we quoted that more specifically in our heads of argument in response of the rule of law. And I can just read that paragraph. It's from paragraph 153 of Barnard, and in our heads in response to the rule of law is at paragraph 21 at page 9. And the court says this at 153: privilege often manifests in an individual in a multiplicity of different intersecting and mutually destructive or constructive or destructive ways. One must account for interactions between the different aspects of identity and privilege when reviewing whether an affirmative action measure was acceptably implemented. Because Ms. Barnard sits at the intersection of privileged and underprivileged identities, she might suffer harm in unique ways compared to members of other groups, designated or not. A woman in her position has probably not suffered the unfair discrimination that Black women did, but also not enjoyed the privilege of white men. Her position and history of privilege are undeniably different from that of a Black man and may require more promotion in some contexts and less in others. So what the court was dealing with there was whether it was justifiable under Section 9(2) of the Constitution to prefer a Black male over Ms. Barnard, who is a white female, because they both fall under previously designated individuals. And the court says, given the history of discrimination in this country, the level of exclusion impacted on different groups within the previously disadvantaged groups in different ways. And therefore, there's nothing unconstitutional in having a restitutionary measure which targets particular groups within that broad group. And in addition to that, the court will see the regulation is not just limited to Black people, it also covers small and medium enterprises which are exempted, and it also covers Black people, but Black females, Blacks, people with disabilities, military veterans, and the rest. And we submit that those legitimately fall within the broad category of previously disadvantaged individuals. So there is nothing wrong in the regulations, particularly targeting Black people, as opposed to simply using the broad category of previously disadvantaged individuals. That is not unconstitutional.
So you can exclude, for purposes of the regulation, exclude women and disabled persons under general, and only say you want women and disabled who are Black for correcting what happened in this scenario.
Yes, and also one must have regard to the context in which the regulations were made. The court will have read the task team report, which shows that, in fact, despite the fact that you have the point system under Section 2 of the Framework Act, many big, large, white controlled companies continue to win tenders without doing a thing about transformation because they can undercut on price. So if you can absorb the 10% on price in high value contracts and give a price that will still give you a higher points, you don't have to worry about transformation. And the reality is, if you carry on like that, you make no dent to redress, economic redress, which lies at the heart of Section 217, 2 and 3 of the Constitution. And there are examples given in the task team report of other countries, Australia, Canada, and United States, which in their case deal with minorities. They have used procurement as a tool to empower minorities, where they in fact set aside contracts which are earmarked for minority groups. It's easier for them because the minorities may be in particular localities. And so you can say, if a tender goes out and the services are to be rendered for a minority group, then the minority must be the ones who compete. And if they can't provide competition, then you open up the tender. In our case, you're dealing with the majority. The irony is that the Constitution provides the framework that we can redress unfair this disadvantage from the past. But we are told that you can't do it in relation to the majority. You must allow the minority to continue to undermine transformation because they can win on price repeatedly. We submit the framework of Section 217, and that is where I was going in my next line after language, is that at the heart of Section 217 is economic redress for previously disadvantaged individuals. And this court has said so repeatedly. It said in Viking at paragraphs 1 to 2, it said that this was economic exclusion was the most pernicious effect of apartheid, and we have to reverse it. And in all pay at paragraph 47, the court makes the same point, that what animates Section 217 is economic redress. And the Constitution, this court, as much as the SCA has done, accept that Section 2172 and 2173 create an exception to 2171. So to the question raised by Justice Chitli, the first starting point is to appreciate that Section 2172 and 3 are an exception to 2171. So one can't say merely, as the SCA has done, if the regulations fail to achieve the objectives of 2171, then they are unconstitutional. Because the SCA itself acknowledged at paragraph 39 of its judgment in volume 9 at page 929. It refers to its previous judgment in AXA versus Imperial, where it specifically said at paragraph 64 that 2172 and 3 are an exception to 2171. And I want to read a paragraph from the judgment of this court in Barnard, and that is the minority judgment of Justice Cameron, Froneman, and Justice Majid, which also says that Section 9, subsection 2 of the Constitution, which allows the taking of restitutionary measures, is an exception to Section 9.1, which is about equality and enjoyment of equal protection of the laws, and 9.3. And this is what the paragraph says, 93, says, and I skip a couple of sentences. The Constitution makes an exception in 9.2 because it recognizes that substantive equality can be achieved only by providing advantages to groups of people upon whom apartheid imposed heavy disadvantages. Even so, we must note with care how these remedial measures often utilize the same racial classifications that were wielded to so invidiously in the past. Their motivation is the opposite of what inspired apartheid, for their ultimate goal is to allow everyone to overcome the old divisions and subordinations. But fighting fire with fire gives rise to an inherent tension. That is why, as the main judgment observes, we must remain vigilant that remedial measures under the Constitution are not an end in themselves. But you do need to fight fire with fire in the hope of building an equal society. And that is why you will have an inherent tension. But the fact that you have an inherent tension doesn't mean that when you name previously disadvantaged individuals, you're acting inconsistently with the Constitution.
Mr. Manechi?
Well,
Teron?
I thought my sister Theron was going to
Perhaps I
ask you a
should allow my
question.
sister Justice Tricky if this is up to her question.
Yes, yes,
Yeah, I'll
it
proceed,
is.
my sister. Thank you. Thank you.
It is a follow-up. I thought that, and I could be wrong, I thought that what section 2172, or we can't read section 2172 without looking at the Framework Act. Because I thought that section 2 of the Framework Act is actually legislation that enables SOEs to implement the objectives of section 2172. Maybe I'm wrong, because I thought that when it comes to the implementation stage, then section 2 of the Framework Act allows SOEs to then do what section 2 of section 217 allows them to do. That is to implement a procurement policy providing for those categories in A and B. So that is why my question to you first was whether section 2 of the Framework Act allows an SOE to upfront exclude those categories.
Yes,
yes. Because what section 11 had done is to say, okay, all of you can apply, but once you have applied, then we've got this point system that will allow us to then act in terms of section 2172. So this is why I asked a double-barreled question.
Yes, thank you, Justice Chief. That is a pertinent question in this case. So I was just saying under the Constitution that the Framework Act comes under 2173, which requires that national legislation must put in place a framework in terms of which organs of state will employ what section 2172 requires. And what is important is also to appreciate that section 2173 requires a framework to be put in place, and the Framework Act does that. Now, to the question Justice Chitli asks, the section 2 of the Framework Act that has been referred to, on its own does not preclude pre-qualification criteria as conditions of tender. What in fact you will see in the section itself is that it does envisage that tenders which are to be evaluated under section 2 will be acceptable tenders. In other words, meeting certain conditions which are prescribed that they must comply with. If I can refer the court to section 2A, which refers to the preference system, you will see that B1 says a point system must be followed for contracts with a rent value above a prescribed amount. A maximum of 10 points may be allocated for specific goals as contemplated in paragraph D, provided that the lowest acceptable tender scores 90 points for price. And 2, for contracts with a rent value equal to or below a prescribed amount, a maximum of 20 points may be allocated for specific goals as contemplated in paragraph D, provided that the lowest acceptable tender scores 80 points for price. And C, you will say, says any other acceptable tenders which are higher in price must score fewer points on a pro rata basis calculated on their tender prices in relation to the lowest acceptable tender. So the first point I make is that before a tender is evaluated under section 2, that tender must be an acceptable tender. And the SCA has recognized that provision, the provision in section 1 of the definition section, which provides that an acceptable tender means any tender which in all respects complies with the specifications and conditions of tender as set out in the tender document, that and what I just read under section 2 all contemplate that organs of state may stipulate conditions of tender, which a tender must meet before it qualifies as an acceptable tender and qualifies for evaluation.
Mr. Manechi, I'm sorry to interrupt you. While you are on section 2, do we have to deal with the proper interpretation of what section 2 means and whether section 2 is limited by section 2171 of the Constitution?
So we would submit that to the relevance of section 2171 of the Constitution is that in compliance with those values of transparency and competitiveness and the rest, is that when you are applying the evaluation process under 2, that must meet the requirements of section 217 within those confines. So whatever, if you're going to allocate points, for instance, for any preference, if you're going to allocate preference points, the invitation to tender must announce that publicly. So there's transparency to all potential tenderers. And secondly, cost effectiveness will require you to evaluate for price, which happens in this context of section 2. And tenderers that tender in acceptable tenders would be evaluated in a competitive way under section 2. So they'll all be, if they're acceptable tenders, they pass the first stage and they must be evaluated in the same fashion. So section 217, the values in section 217 remain relevant to section 2. But where we submit the SCA got it wrong is to say that because when you have preferential or pre-qualification criteria, which have the effect of preferring, say, Black people, and I'm using it generally because they prefer other categories there, that the mere fact that the effect of that would be to exclude certain tenderers, that breaches 2171, renders that unconstitutional. We submit what the SCA did not do was to evaluate whether, nevertheless, those pre-qualification criteria, even if potentially excluding certain parties from tendering, promote the objectives of 2172 and the objectives of the Framework Act. Because if they do, if they are consistent with section 2172, they cannot simultaneously be unlawful for inconsistency with 2171. If one accepts that 2172 and 2173 create an exception to 2171, you can't say this pre-qualification criteria advance the objectives of 2172, but they are nevertheless unlawful because they fail to advance the objectives of 2171. That is to suggest that there is a conflict between 2171 and 2172 when there isn't, because the one that provides the general principles under sub 1 is qualified or accepted from by 2172, and that is in line with the jurisprudence of this court. And so once we can show that the pre-qualification criteria are consistent with 2172, the only question is whether they are inconsistent with the Framework Act. And that's where Justice Chitwi's question comes in, because Justice Chitwi suggests that the Framework Act has exhaustively dealt with economic redress under section 2. You can't do anything else. If you're going to transform, you must apply the point system, and that's it. We submit with great respect that that is not what the framework does. Because if you look at the Framework Act, although the Constitution under 2173 says a legislation must create a framework in which to implement the objectives of 2172, what the legislature does in putting the framework together under the Framework Act is it gives certain powers, additional powers to the minister If I can point out two of those powers, and I leave out for the moment the notion of an acceptable tender. If you look at 2 subsection C, which I've read previously, says any other acceptable tenders which are higher in price must score fewer points on a pro rata basis calculated on their tender price in relation to the lowest acceptable tender in accordance with a prescribed formula. That formula must be prescribed, and the Act says prescribed means prescribed by regulation under Section 5. So it leaves, again, a role for the minister, if I can use the word, to augment the framework. So the framework is not complete and exhaustive, and it can be augmented by regulation. Secondly, you have Section 5.1, which says the minister may make regulations regarding any matter that may be necessary or expedient to prescribe in order to achieve the objects of this Act. And we have identified that the objects of this Act is to provide a framework for the implementation of the Section 2172 objectives and to provide matters connected therewith. So even at that level,
but
the minister...
Mr. Vaneche,
Justice Matanga?
Yes, there's a huge difference between your first example and your second. Your first example falls squarely within what one usually sees in statutory provisions that empower the making of regulations. Because regulations ordinarily provide nuts and bolts to an Act of Parliament, which sets out what it requires. More in broad terms, I use broad very loosely, of course, because the statutes can be quite detailed and often are. But the nuts and bolts as to the exact how then get provided for in regulations. So your first example fits in falls squarely within that. Whereas your second example doesn't. It's not all about nuts and bolts. To my mind, it sounds more like a plenary, rather the delegation of plenary legislative power. The difficulty I have with that is, I forget the judgment, but it's a judgment, I think, by Shaskalson P. In which he says generally it is unconstitutional to delegate a plenary legislative power to an entity that is not a legislature. I'm sure you are well aware of that principle. Now, you did, of course, right at the beginning say that there's no constitutional challenge to Section 5. I understand that. But bearing in mind the point I've just made, or the principle that I've just referred to, is it not so that we would have to interpret Section 5 in the light of that principle and restrict its meaning in accordance with that constitutional principle?
Yes, let me just, I accept the distinction that Justice Madlanga draws between C and Section 5. But what I submit is that the distinction is not one of great substance, because what the regulations do is also to provide the how or the content of conditions which would determine what an acceptable tender is in sub 1. So the Act does not tell you what is an acceptable tender. What it says is that it is that which organs of state may impose. And what the minister does in the regulations through Section 5, the Section 5 regulations, is to provide content to what conditions may be prescribed by way of conditions that govern what an acceptable tender would be. And this has been done also in relation to the question of functionality, because as you will see when you go through this act, there is no provision in the act which says that a tender must be assessed for functionality. So one would, reading the act, one would be forgiven to assume that all that the legislature is interested in is price and empowerment. But what the minister then does by way of regulation is to provide for functionality as a condition for an acceptable tender. And that is done was done in the 2011 regulations. If I can just give the references to the court, the 2011 regulations will be in volume 2 at page 185. And regulation 4.4 says, no tender must be regarded as an acceptable tender if it fails to achieve a qualifying score for functionality as indicated in the tender invitation. And in the 2017 regulation, one will find it in volume 1 at page 35. Regulation 5.6 says a tender that fails to obtain the minimum qualifying score for functionality as indicated in the tender documents is not an acceptable tender. And the current regulations do the same thing. They simply say, if you don't meet this pre-qualifying criteria, and if an organ of state chooses to apply those pre-qualifying criteria, that tender is not an acceptable tender. And as I said, the SCA has accepted in previous cases that an organ of state can determine conditions which must be complied with for a tender to be acceptable. In other words, for a tender to pass the first threshold before it gets into section 2 evaluation. And one of them is Chairperson Standing Tender Committee and others versus Sapela. It's cited in the respondent's heads of argument. At paragraph 11, it simply repeats that for a tender to be eligible for consideration, i.e. for the allocation of points, it must be an acceptable tender as defined in the Framework Act. And the Framework Act simply tells you that what is an acceptable tender. It must meet specifications and conditions of tender, but doesn't tell you what those conditions are. And then in Dr. J.S. Morocco, if I can just complete that, just in and I come to the question. In Sapela, in Dr. J.S. Morocco, which is also cited in the respondent's heads, at its case 9 in their list, at paragraph 10, what the SCA says there is, essentially, it was for the municipality and not the court to decide what should be a prerequisite for a valid tender. And a failure to comply with prescribed conditions will result in a tender being disqualified as an acceptable tender under the Procurement Act, unless those conditions are immaterial, unreasonable, or unconstitutional. And I'm going to go through those conditions to submit to the court that they are not unconstitutional and therefore fall in line with what the minister could do. So the Western Cape judgment that Justice Madlanga refers to says you can't delegate plenary powers. Now, to determine whether these are plenary powers, one would have to determine whether what the minister has done in any way amends the Framework Act or what has done is in conflict with the Framework Act. Because if it doesn't breach that principle that the minister cannot be delegated plenary powers, we would submit. Just in country, I know this is
where would you say, if you say there's breach, where would you say in the Act itself there's something that envisages the pre-qualification? In the substantive, let's leave out the long title for a minute. Where in the substantive provisions of the Act is there something that envisages pre-qualification? I do see a section 2 something D, and that of course is not about pre-qualification, but it is about point scoring, taking into account the factor of previously disadvantaged people. But where would you say in the Act itself there is provision that envisages pre-qualification?
We submit that it's in the broad power given in section 5.1, read with the requirement for acceptable tenders under the Act, in the definition and in the various provisions of the Act, which make it clear that it's only an acceptable tender that gets into the Section 2 evaluation stage. And our submission is that grants the minister, where the organs of state have power to determine conditions.
It would only not be acceptable because you've already provided for pre-qualification. So without first having provided for pre-qualification, this unacceptability would not arise at all. I don't quite get that.
Yes, we accept that. So it's the same as saying a tender would otherwise be acceptable if there was no requirement for functionality. But the minister has promulgated functionality as a prerequisite, as a pre-qualification.
Then of course, that begs the question, because one would ask a similar question with regard to functionality, but of course, that's not what we are about now.
Yes, but we would submit that
I don't think the fact that it has been done in respect of this, and there is not necessarily a challenge before us about that, answers my question or answers the issue that I'm raising. I hope I'm making sense.
I understand. I'm not using it as an answer to the legal question. I'm using it to demonstrate the kinds of conditions which is permissible for the minister to put in place by way of regulation. And we source them in the general power read with the requirement for acceptable tender. And we submit that the minister would have difficulties if what he puts in place conflicts with the Framework Act. And if there is a conflict, then one can say he's crossing the line into exercise of plenary powers. And it is the exercise of examining whether there's a conflict which I would like to come to. But yes, Justice Madlanga.
Just a comment, Mr. Vaineche. I think the legislature lost an opportunity afforded to it both by sections 2172 and 3 to clearly set out what section 2172 wanted to be achieved. The legislature seriously missed out on an opportunity that it was given on a silver platter by the Constitution. But as I say that, no, I'm not then saying there is no basis for the interpretation that you proffer. Yes. The legislature could have been more direct, and we would not be having the debate that we are having now.
Precisely. But of course, the legislature had options to implement to achieve the same objective, to allow for flexibility in the framework, and recall the words used in 2173 is to create a framework. It's unlikely a framework will be exhaustive and contain all the required detail. And what the legislature did to allow for that broad framework and flexibility was to give the powers that it gives to the minister under section 5.1, not only to achieve the objects of a particular section in the Act, but to achieve the objects of providing a framework, which is what the long title tells you. So in a sense, it says, here's a framework to the extent that we need nut and bolts, for example, in relation to what an acceptable tender is and what organs of state can do. We give the minister the power to do so. It's important in the one case in the AXA versus Imperial judgment, Justice Madlanga, in relation to AXA. What AXA had sought to do was realizing that the point system are defeating the object of section 2172 to adopt its own criteria and say certain contracts will be awarded to those that have 51% BEE, for example. And what the SCA said is you can't do that without the consent of the minister, because the framework that is designed envisages that first the legislature has created a framework and then is given certain powers to the minister. You can't, as an organ of state, just adopt your own criteria. And now the minister exercises the power under 5.1.
Isn't that exactly what section 2.1 says? Is it exactly saying each organ of state? Well, let me just look at the section now. Please just bear with me a couple of seconds. Each organ of state must determine its preferential procurement policy. And of course, by preferential procurement policy, this goes back to sections 2172 and 3. So each organ of state must determine its own and then implement it within the framework that appears from A downwards. Now, if that be so, surely this must mean that AXA, ESCOM, the Department of Finance, and whatever other department and whatever other entity that fits the definition of organ of state should be able, just like AXA did, to determine its own quote unquote preferential procurement policy. Isn't that exactly what section 2 says, 2.1 says?
No, but well, first, what AXA sought to do was to impose a threshold requirement which would as this qualification criteria would do, make sift at the very first stage before you come into section 2. So what AXA sought to do was not what falls under section 2, was something antecedent to section 2, which is what the pre-qualification criteria does. As Justice Chiefly asked is, can you exclude others even before they get into section 2?
Or maybe let me ask my question differently then. Is it not so that what the minister has done by way of regulations is exactly something that organs of state could each do in terms of section 2.1?
No, with respect, they don't have the power to do that because they can only implement any procurement policy by implementing this point system that is set out.
I'm at the level of determination before we get to implement, Mr. Maineche.
So I'm saying even determination.
There are two verbs there.
Yes.
Verbs.
They can determine their procurement policy, but that procurement policy cannot allow for implementation which falls outside of what is provided, the point system under section 2. So that's
how is the minister able to do it? Purely because
no, because the minister is not interfering with section 2. The minister is dealing with a step antecedent to section 2. He's dealing with.
But if you say there's a problem between the determination and the implementation insofar as the organs of state are concerned, I have difficulty understanding why at the level of implementation, there will be no problem if the preferential procurement policy has been determined by the minister. Why suddenly isn't there no problem with implementation?
Because what the minister is regulating a level up before section 2 is determining what would be an acceptable tender. So if you take, for example, in the regulations, the category of entities that are just EMEs or QMEs, small and medium enterprises, and there's no issue about race involved in there. So when you have a tender which says, in order to qualify for evaluation, you must be an EME or a QME, despite race, a tenderer who is an EME or QME would come in, say 5 of them enter because their tenders are acceptable tenders as per the definition in the first level, the pre-qualifying stage. Then they would enter the level 2 evaluation and they would be evaluated on price and BEE. So that's the difference between that's why there is no conflict between what the minister does and what section 2 provides for, because each of them are regulating different levels of the tendering process. So there can be no conflict.
Please, bearing in mind, thank you, Ms. Please, bearing in mind the difference between determine and implement, envisaged in section 2.1. Can you please give me examples of the preferential policy, preferential procurement policy that organs of state, qua organs of state, may determine before then implementing in accordance with the framework set out in the section? What, do you have any ready examples perhaps? That will help me understand the distinction that you are seeking to draw between what the minister may do and what organs of state may do.
Yes, so here I would have to also bear in mind what other legislation requires of organs of state. So organs of state, for example, under the PFMA and the MMFA, which deals with local government, are required to adopt and implement procurement policies. So they determine and implement their procurement policies. Because the Framework Act is only concerned with preferential procurement, it regulates those aspects of their policies which would bear upon preference. And so what the Framework Act says, if when you determine your procurement policy, you're going to implement a system of preference or a policy of preference, when you determine and implement it, it must be in line with this. So in their policies, they would say, for contracts of a value, say the minister currently, the values are up to 50 million rand. Up to 50 million rand are regarded as low value contracts. Above 50 million rand, they are high value contracts. So below 50 million rand, you apply an 80-20
you are at the level of implementation now. My interest is at the level of determination. What may the organs of state, what preferential procurement policy may organs of state determine?
Yes.
Usage in section 2.1. Before implementation, I get the 90-10, 80-20 point scoring system with the rest. Yeah. I get that. And I also get your point about the advantaged entities readily winning the contest purely based on the advantage they have on the 90 or the 80. I get your point in that regard, but that's at the level of implementation. I want to focus on determination. What type of preferential procurement policy may the organs of state determine?
Yes. So they may determine that they want to advantage categories of people or particular types of contractors like small and medium enterprises, and maybe disabled people or youth. They may determine that that is going to be their policy. So they're going to, in procuring advantage, so prefer those individuals. And what, or entities, and what the section 2 says is it then identifies what preferential goals may be in that policy which the organ of state wants to determine. If you tend to section 2D,
are you going to D now?
I'm going to D, yes.
Paragraph D. That's part of the implementation.
Well, no, with respect, it's not, because
it's not all. Okay.
It's not, because the paragraph 2, section 2 is the preamble, which tells you an organ of state must determine its preferential policy and implement it within the framework. So the and conjunctively means the two, determining and implementing, both of them must comply with this framework.
No, I get your point. I get your point with regard. Yes.
And then D
will then be within the 10 or the 20.
Yes, so first you have the point system, but D is very important because it limits the goals that you may seek to achieve by preferring. It says, 1, you can contract with persons or categories of persons historically disadvantaged by unfair discrimination on the basis of race, gender, or disability. And 2, you can implement the program of the Reconstruction and Development Program as published in that government gazette. Those two they do not tell you that you can also prefer small and medium enterprises. So an organ of state has no ability, limited by Section 2, to go as far as the minister can go under Section 5.1 when he's dealing with what an acceptable tender is.
I'm not sure, but anyway, thank you very much.
I come in?
Thank you, Mr. Manager.
Thank you, Justice Madlang.
Mr. Manager, I'm interested in the debate that we're just having with Justice Madlanga. And I want to say, it looks to me that one, as Justice Madlanga has put it, the purpose of Section 2 is to do two things. And those things do happen sequentially. You first determine the policy. Once the policy is there, then you implement it. So we have to understand that when reading Section 2 and not to conflate the two because it creates some confusion. Now, when you come to paragraph D, would you agree with me that D is not limited to the two listed? It says the specific goals may include. So it doesn't tell us what are other specific goals that an organ of state may seek to achieve other than the listed ones. But the language is clear that those are not the only specific goals that an organ of state may pursue. Now, isn't that suggestive then that in the determination of the policy, these other specific goals have to be set out? And those specific goals must be goals that are designed to attain the objective of Section 217 sub 2. Or am I wrong?
No, Justice Jafta, you're not wrong. You're not wrong that the Section D, subsection D is not exhaustive. It leaves the scope wide for other goals, but that those goals must be consistent with, must promote the object of 2172, that's correct. But they would still be subject, of course, to the framework point, which is in 1. And I accept that Justice Jafta is saying the determination comes first and then the implementation.
Yes.
But both of those are governed by the framework under Section 2.
No, I accept that.
Yes.
But remember, this whole debate that you had with Justice Madlanga is linked to Justice Chike's question. How can you upfront say only this group of people are eligible to tender?
Yes.
Is that upfront indication covered by the section? Remember the debate that you had about plenary powers and delegated powers. So we're trying to find out from this subsection whether one can upfront say, these are the specific goals that I have decided upon, which are designed to achieve the same objective, which is in Section 217 sub 2. Now, the question is, those other specific goals, if they are not mentioned upfront, where would they be mentioned? How would tenderers know that this specific organ of state has other specific goals other than those that are listed in D?
Let me deal with those, the two questions. The first question is, does section 2 provide for a pre-qualification, for any pre-qualification conditions or criteria?
Yeah.
It doesn't, because section 2 assumes that you now have an acceptable tender which can be evaluated under section 2. So he's not concerned with pre-qualification.
Now,
Because
aren't you undercutting the debate that you had with Justice Madlanga about determination? If you still want to determine, how can we say we're proceeding from the premise that you already have an acceptable tender when you're still going to determine the policy?
If now I understand the question. So in the sequence of determining, so if what the regulations provide for is that if an organ of state wishes to apply pre-qualifying tenders under regulation 4, those pre-qualifying conditions would have to be announced in the invitation to tender. So there will be a statement in the invitation to tender to all bidders that pre-qualifying criteria will be applied. That is the same as when an organ of state invites tenders which will be evaluated for functionality, which is a pre-qualifying criteria. So the regulations are very specific that if an organ of state is going to apply pre-qualifying criteria, those would have to be indicated in the invitation to tender.
But Justice Madlanga's concern is that that cannot come from the regulations themselves, because that looks like plenary, exercise of plenary power. He says, no, before you go to the regulations, show me in the act itself what permits the minister to do what the minister has done in promulgating the regulations.
Yes, and the answer I've given, and that's the only answer we can give in the structure of the Act, is that power is sourced in the general power under section 5.1, and that permits the minister to prescribe what is necessary or expedient, and that relates to tenders that would be acceptable or not acceptable in terms of section 1. In other words, what organs of state can impose as conditions of tender which would govern what an acceptable tender is. That is where the power comes from. With respect, Justice Jafta, it doesn't come from section 2, because section 2, as I've submitted earlier, section 2 is at the second stage where you're now assessing an acceptable tender for the allocation of points.
I think you're complicating matters for yourself. Because section 2 really speaks of determination. It can't be determination when everything is already in line. You have an acceptable tender. Otherwise, that term determine in 2 would be meaningless. And I thought when you go into D, by showing that D is not exhaustive, surely Parliament had anticipated that an organ of state might still have other specific goals which are not spelled out as those which are listed. But it may follow those only if those goals are rationally connected to the purpose of section 217, section 2. And if you look at E makes it more clearer. And E says, any specific goal for which a point may be awarded must be clearly specified in the invitation to submit a tender. So the upfront is there.
Yes.
Okay. So isn't that really helping you to overcome the hurdle that, or the concern that Justice Madlanga was putting to you. Because he says, look, at 2.2 says, you do two things. You first determine, once you have determined, you have to implement.
Yes. Justice Jafta, I must acknowledge that the point you raise in relation to determination. So all that the minister says is, if in your determination of your policy, you decide that you're going to apply any pre-qualifying criteria which must be rationally connected to the objectives of 2172, these are some of the pre-qualifying criteria that you may legitimately adopt. And the minister does so quite legitimately, because he leaves it to the discretion of the organs of state to decide whether they are going to apply pre-qualifying criteria in their policies. So one can read it in the way in which the Justice Madlanga and Justice Jafta suggest to me, that there is scope there for organs of state to adopt those kinds of goals. And all we are submitting is that the minister is not prescriptive to the organs of state. He says it's in the discretion of the organs of state to adopt the pre-qualifying criteria. And we submit that there is a rational connection between those pre-qualifying criteria and the purposes of Section 2172, and there is no conflict with the Framework Act.
Mandachi, may I raise a related concern to those raised by my brother Madlanga? This pre-qualifying criteria of race seems to be covered already in 2.1d, which specifically mentions inter alia race, gender, disability. Would one not be taking it into account twice, where that features as a pre-qualifying criteria, the question of race? I ask that in the light of 2.1f, which says the contract must be awarded to the tenderer who scores the highest points unless objective criteria, in addition to those contemplated in paragraphs D and E, justify the award to another tenderer.
Yes.
This is not a question of taking into account that one factor twice, which the regulations certainly can't do as delegated legislation.
Section F governs a different situation, which is when you have those that have properly be allocated points for price and BE, which and determining which tenderer must be awarded the tender, that you can take, you can award to the one that doesn't score the highest points, taking into account objective criteria. The legislation doesn't allow you to use BE because it would have been taken into account already as an objective criteria. We accept that, but nothing with respect precludes using the race as part of pre-qualifying criteria at a stage prior to the award stage. And we referred to the judgment of Justice from Namanezi, then was in the High Court, where he expressed the same view that they couldn't be where you're dealing with different stages, as long as you're not taking into account at F, you're not using race, because the section specifically says it must be objective factors that are in addition to, say, functionality would be a different objective fact, because it is not scored, it's simply used as a threshold requirement.
And then a second concern, regulations 6 and 4 say that 6 sub 4, sorry, say a tenderer failing to submit proof of BBE status, level of contribution, or is a non-compliant contributor to BBEE may not be disqualified. Does that not potentially conflict with regulation 4?
With respect, not because, so you have two scenarios potentially. You have a scenario where an organ of state implements a pre-qualifying criteria which includes race. In that case, or stipulates that there must be 51% shareholding by Black people. In that case, in order to prove that shareholding, you would have to produce your BE level contribution certificate, which comes from DTIC. So you wouldn't be able to avoid that in order to pre-qualify. But the second scenario would be where the organ of state does not apply pre-qualifying criteria based on race at all. In that scenario, you could have anyone tendering. And so if you tendered and you didn't produce your BE certificate, but have given the lowest price, you could still win in terms of the point system. So the mere fact that you didn't produce your BE certificate would not automatically disqualify you. So there's no conflict between the pre-qualification criteria and 6 sub 4 in that sense. If I may then get to conclude. So in respect of the SCA judgment, what we say the fundamental error the SCA made was to say that because the pre-qualifying criteria do not advance the objectives of section 2171, and the court will find that in paragraph 38, the regulations are inconsistent with the Constitution. And that framework of reasoning informs the findings which you will find in paragraphs 40 and 43 of the SCA judgment. In other words, they say you can't exclude others from competing at the threshold stage, because when you do that, you conflict with 2171. We submit that that is an erroneous way of assessing the points, because you've got to look at the whole of 2172 as the SCA then said in Millennium Waste. I think Justice Jafta wrote the judgment for the court that one must look at section 217 as a whole, bearing in mind 39.2. So because section 2172 and 3 are an exception to 2171, where the goals of the pre-qualifying criteria are rationally related to the objectives of 2172, they cannot be simultaneously unconstitutional because they don't advance the object of 2171. And we submit that that is the centerpiece of the SCA's judgment. And once that reasoning is not accepted, we submit the appeal should succeed.
Doesn't it mean, Mr. Manager, doesn't it mean that the SCA reasoning suffers from the same defect that Justice Madlanga has just revealed in the debate with you? It seems to me that the SCA conflates implementation with determination. Would it be wrong to say once the exclusion has been put up and only tenderers from that group submit tenders, when the implementation or the evaluation of the tenders is done, then section 2171 will be applied within that group. So I don't understand why one would think that section 2171 doesn't apply. It applies within that group to check competitiveness, to check effectiveness, but within the group itself. So that's how I've seen the flaw in the SCA reasoning, which is shown by the debate that Justice Madlanga had earlier on, that people are conflating two things that are separate: the determination of the policy before it is implemented and the implementation of that policy. It doesn't mean that When it comes to those who were previously disadvantaged, suddenly the requirements of Section 2171 are irrelevant. They still relevant.
Justice Jafta, I'm indebted to you twice. that is correct. So the argument I made earlier about exception applies to the determination stage, but the implementation stage, and we have made the submission, and the High Court makes the finding that once you have determined the policy, when you implement the policy, everyone must compete transparently, cost effectively. All of those factors come into play. That is the proper framework to look at the issue, Justice Jafta. I'm indebted to you.
In a sense, also, Mr. Maineche, the reasoning seems to be at odds with what this court held in, was it Van Heerden?
Yes.
Yeah, to the extent that the judgment said, if you are satisfied that what has been done here, even though it differentiates on the basis of a race, which under Section 9.3 would be presumptively unfair discrimination, you cannot impugn it on the basis of Section 9.3, because then it would mean there's an internal conflict or contradiction between Section 9.3 and Section 9.2. So in a sense, I think your argument on this point accords with what Van Heerden held.
Just Madanga, I couldn't put it any more eloquently than you. That is absolutely right. And that is where the error of the SCA manifests, the fundamental error.
Do you have to say anything about the fact that the state organs have a discretion insofar as to apply this pre-qualification criteria? And also the fact that it's not a closed list, basically. It's only related to subcontracting and certain groups. So it does not mean that everyone is going to be excluded. If you look at for, it's clear that it's a tenderer with a minimum triple BEE, a EME or QSE, or a tenderer subcontracting.
Yes, Justice Mkantla, the point about discretion and not being a closed list relates back to the question that Justice Madlanga and Justice Jafta debated earlier, which is that the discretion leaves it to the organs of state to determine whether they're going to implement any pre-qualifying criteria as part of their policy of preference. And it's not a closed list, so they can have additional goals which they may want to advance. And we submit that makes it consistent both with the Constitution and the Framework Act.
Thank you.
Unless there are further questions, those are submissions on the appeal, and my learned friend, Mr. Stubbs, will deal with the intervening party, and I'll just move for him to sit here and address the court.
Just before you move, Mr. Mayeneke, you had also asked for, are you still persisting with the question of cost if you are successful?
No, we accept that this is we said is an important constitutional issue. I can't simultaneously ask for costs.
Thank you.
As the court pleases.
Thank you, Mr. Stubbs. You may proceed.
Thank you, Acting Deputy Chief Justice. And may it please the court and the justices of the court, I, as my learned leader mentioned, am here to respond, hopefully concisely, to Fidelity's urgent interlocutory application. There are several prayers for relief in the interlocutory application, but in effect, each prayer is designed to achieve the same object we would submit, namely an urgent interim suspension of subordinate legislation that's applied by organs of state across the country, pending this court's final decision in the main application. Now, the 2017 regulations came into effect in around January 2017, but the applicants have brought their application on an urgent basis on 12 April, over 4 years later, seeking urgent relief from this court as a court of first and final instance on the basis of new facts. Now, we submit that the application may be dismissed for a number of reasons, both preliminary and in regard to the merits, and I shall shortly explain why. It may be convenient, justices, and most concise if I use as my crib sheet, as it were, if I take the court to the notice of motion of fidelity of the applicants in the urgent interlocutory application, which is at pages 2 to 4 of the notice of motion. There, the relief that's sought is set out, and it may be best then for me simply to address the prayers for relief and why we respectfully submit that they should be rejected. I'll do so in a mixed up order, and I'll do so hopefully for reasons that will shortly become clear, that some of the issues overlap and follow sequentially. I'll start with prayer 4. I'll then move with prayer 6, which is the prayer seeking a directive. I'll then move to prayer 5, which we'll submit is really the main meat of the application to the extent that there is such. That is the interdictory relief, sorry, justices. And then prayer 1, then prayer 5 then ends the substantive relief that's sought. And prayer 1 is then about urgency. That will be the next one that I'll address. I'll address prayers 2 and 3 together because the tests for them are effectively the same, and then move on to prayer 7. As regards prayer 4, prayer 4 is a prayer that asks for the SCA judgment to be enforced. Now, I started in my introduction saying that the objective of this urgent application, as is set out clearly in the affidavits, is in order to ensure that the regulations are suspended. The SCA order, if the SCA order were to be enforced, that would include paragraph 2C of the SCA's order, which is, yes, Justice.
The fact that the intervening parties have not cross-appealed against the ACA's decision to suspend the order of invalidity, is that of any significance?
Yes, milady, we submit that it's of vital significance for reasons that we've touched on in our written submissions, but in summary are that the SCA order as it stands says that the regulations should not apply. It doesn't say that verbatim, but in effect, it says that its order of invalidity is suspended. If there's no cross appeal against that order and the applicants seek to enforce as they do, then the legal effect of that will then be self-contradictory, if I can put it that way. It will be to achieve the opposite end to the end that the applicants are seeking to achieve expressly. And without a cross appeal, we submit that there's no way that the applicants cannot escape the effect of enforcement. In the absence of cross appeal, there's no scope for that order to be amended, especially in an interlocutory context, as is the present, Justice Trump.
Mr. Stubbs, shouldn't they have approached the SCA for enforcement, because the SCA's order is that it suspends the order of invalidity. Now, if they don't want the order to be suspended, shouldn't they have gone to the SCA in terms of the Supreme Court's rule? I think it's 18, if I'm not mistaken, for the enforcement of that order.
Beg your pardon, Justice Mhlanga, and thank you for the question. I'm indebted because that's precisely what we respectfully submit that they should have done. And I think it would not be the first time that a third party has intervened at the appellate stage. I believe that my learned leader was involved in one of those occasions. That was the Sedumo case. The applicants say that they weren't able to go and intervene at the SCA, Justice Mhlanga, but precisely the opposite is the case. We would respectfully submit because of Section 18. Section 18 makes very clear that the court giving the order is the court that needs to be approached. And to Justice Theron's earlier question, which then complements Justice Mhlanhla's question with respect, because there is no cross appeal, the application is then dead in the water, at least prayer 4 is. So in other words, there are a number of different reasons that prayer 4 is stillborn, we would submit. One of them is that they needed to approach the court giving the order and they did not do so. Another is that they needed to cross appeal and they failed to do that as well. And that being the case, the enforcement of the SCA order, it blows up the relief that the applicants actually seek. So yes, the short answer to your question, Justice Mhlanhla, is we would respectfully submit yes. Now, I don't know whether prayer 4 is seriously persisted with. The applicants don't appear to persist with it seriously in their heads of argument, but I thought that it bared addressing in order to ensure that the court is fully apprised of our position as the applicants. So we submit, for the reasons that Justice Mhlanhla and Justice Theron refer to, that prayer 4 then falls by the wayside, if I can put it that way. Then that would then take me to prayer 6, which is the prayer in which the applicants seek a directive from this court, then imposing upon the Minister and the Minister of Public Enterprises the obligation to issue a directive to all organs of state, or ESCOM, SABC, and the like. I believe the turn of phrase is used, but we understand that to mean every organ of state. And if that's the case, then the Minister needs, if prayer 6 is to be granted, to be given an order to exercise his executive discretion to direct other organs of state to not apply a law. Now, putting it in that way, we respectfully submit, Justices, demonstrates the clear non-joinder that the applicants have made themselves guilty of. If we are speaking about an order from this court that is intended to have an impact on organs of state, what do the organs of state have to say about that prospective order? Well, the answer is that they have nothing to say because the applicants have not cited them as parties to the application. So the applicants have effectively engineered something of an ex parte situation where they want organs of state to be bound by relief that's sought, but where those organs of state have no say in whether or not that relief is granted. The test for non-joinder is set out in our heads of argument. I beg your pardon, did I miss a question, Justices? Beg your pardon, okay. The test for non-joinder is set out in our heads of argument, but it's trite, we would respectfully submit. There has to be a direct and substantial interest. Is there a direct and substantial interest in this instance? We would submit yes, Justices. The order bears on the organs of state. But that's not the only problem with prayer 6 we would submit. Prayer 6, framed as it is, constitutes an order seeking a mandamus, an order seeking an administrative functionary, seeking a direction to be imposed upon an administrative functionary to take a positive action in terms of law. They want the Minister to take positive action and issue these directives. The question that the court will ask itself, we respectfully submit, is, well, firstly, can the Minister do that? On what basis can the Minister do that? And we submit that there's no basis in the Preferential Procurement Act at all for a directive to be issued by the Minister to organs of state. I would tentatively refer to the debate that my learned leader and Justice Mazanga and Justice Jafta were having in regard to the discretions of organs of state. How can the Minister place himself in the shoes of organs of state or give organs of state directives that they must slavishly follow in terms of a court order? There's no basis for that, we would submit. Organs of state need to exercise their own discretion, and prayer 6 gives no scope for that. There are also no grounds we would submit. This is a related point. The next question would be, well, what would those organs of state do with the directive from the Minister? What are they meant to do with the directive from the Minister, which has no basis in the statute? We would submit very little justices with respect. If there is no basis for the minister to give such a directive, then there are also no grounds in law for the organ of state to comply with it. And so in that manner, we respectfully submit that that then is the end of prayer 6. So we would then have crossed off, if the justices are with us, crossed off prayers 4 and 6, as it were, and moved to prayer 5, which we respectfully submit is probably the main meat of the application. Now, prayer 5 asks for what we submit is quite seriously far-ranging relief. It is an interdict against the application of subordinate legislation. The applicants ask for an interdict of that nature. Now, we submit that there are a number of different ways that the court may dismiss it, including on the merits. The first point to mention is that we submit that that is not what interdicts are ordinarily meant to do. They're not meant to interdict a member of the executive from applying a law that is a law of general application. The law either applies or it doesn't. It is a law. It is that simple. We respectfully submit that an interdict is not the appropriate form of relief to seek in that context, but there are other reasons that we respectfully submit that prayer 5 falls by the wayside. And those have to do with the merits. Now, when it comes to interdictory relief, it's trite that there are 4 different requirements, and I won't bore the court with a rehearsal of those requirements. I'll simply confine myself to explaining why we respectfully submit that they do not and cannot meet the requirements for interdictory relief. The first requirement being a prima facie right. Well, the way that this was framed initially by the applicants was they believe that they have a prima facie right on the basis of the SCA order as it stands. And I don't believe I need to spend too much time on that because of Justices Mhlanhla and Justice Turan's questions. Those bear on that issue as well. The SCA order says the 2017 regulations don't apply. That's what it effectively says. So how can one have a prima facie right to the 2017 regulations not applying? We respectfully submit that one can't have such a prima facie right, but it does seem as though the applicants, perhaps aware of that difficulty, have shifted ground to a second peg for their prima facie right, which is that they submit that the new facts that they set out in their application justify a prima facie right. We submit that that's not the case either with respect, and cannot be the case with respect. And there are a number of reasons for that. The first of which would be, firstly, new facts are the fulcrum of the applicant's case. I think the applicants addressed that at paragraph 18 of page 19 of their founding affidavit, where they say, and quoting, the applicants approach this honorable court as first instance as regard to the facts they wish to place before the honorable court. So we have a clear and explicit statement that new facts are sought to be placed in this application before this court. The gateway requirement for new facts to be admitted is Rule 30, Rules 30 and Rule 31. I think recently this court held, per Justice Katri Setulwana in SOS Support Public Broadcasting Coalition and others versus the South African Broadcasting Corporation and others. That's 2018 ZACC 37 at paragraph 67, held that Rules 30 and 31 are the test for the admission of new facts. New facts are not admissible as of right. This is, of course, the highest appellate court in the land, not a court of first instance. And it's well established that a litigant can't advance new facts before this court as of right. What the applicants must do is show this court that there are exceptional circumstances that justify the admission of the new facts. If they don't do so, we respectfully submit that they don't get out of the starting blocks on their alternative prima facie right argument. And we submit that they cannot do so. Well, for a number of reasons, for 2 or 3 reasons at least. The first is that one searches in vain for a reference to rules 30 or 31 in the applicant's pleadings. And pleadings obviously would be the starting point, as is well established. If the applicants don't try to meet the threshold, then they cannot meet the threshold. Their prima facie right argument doesn't leave the gate. Secondly, the alleged facts that are advanced in terms of the rule need to be either common cause or incontrovertible. That's the explicit requirement in the rule, as the justices would be well aware. Now, we respectfully submit that it would not be appropriate, and we say that with the greatest of respect, of course, would not be appropriate to reach a finding that these facts are common cause or incontrovertible in circumstances where the applicants have elected not to cite the organs of state who would be in a position to controvert the facts advanced, who would be in a position to say, well, these facts aren't common cause. And in any event, the minister does not make common cause with the applicant's factual version either. So that would be the second reason that rules 30 and 31 haven't been complied with in our respectful submission. And then the third reason is what in the SOS case, this court referred to as the pivotal requirement, quoting the court, I think at paragraph 68. The pivotal requirement for advancing new evidence is that the evidence sought to be admitted must be, quote unquote, relevant to the issues to be determined by this court. We respectfully submit that they could not be more irrelevant to the issues to be determined by this court. And the reasons are, perhaps in Afribusiness's own words, in Afribusiness's heads of argument, Afribusiness states that this application is concerned with, quote, solely and exclusively concerned with matters of statutory interpretation, and is founded upon propositions of law. So that's not facts, propositions of law. The subjective experience of the applicants in this urgent application, we submit, could never be relevant to this inquiry because of what this court held in Ferreira versus Levine. And I think that will be the one case that I'll quote, where the court held at paragraph 26, I believe, the question whether the invalidity of a statute is determined by an objective or a subjective inquiry is that the inquiry is an objective one. A statute is either valid or of no force in effect to the extent of its inconsistency. The subjective positions in which parties to a dispute may find themselves cannot have a bearing on the status of the provisions of a statute under attack. The consequence of such a subjective approach would be to recognize the validity of a statute in respect of one litigant, only to deny it in respect of another. And we submit that dictum is directly on point when it comes to the question of whether the applicants can establish a prima facie right. They cannot for that third reason. And importantly, justices, that then means that the application falls to be dismissed on its merits without more. We don't need to interrogate whether irreparable harm has been satisfied. We don't need to look at balance of convenience, nor do we need to look at an alternative remedy, because the requirements are conjunctive. The applicants have to meet all of them. And if they fail at the first hurdle, then they fail at the race. That being the case, I will then briefly move on to irreparable harm, balance of convenience, and the alternative remedy. Irreparable harm, we respectfully submit, also is not satisfied because the irreparable harm submissions are premised on the idea that it has been demonstrated to this court as a court of first and final instance that the applicants are losing tenders. Losing is the word that's used. That we submit is premised upon, well, it's premised on an erroneous assumption that there is an entitlement to obtain tenders, and that it has been that it is indeed so that the applicants have lost the tenders. In any event, the applicants don't adequately address, we respectfully submit, that any harm that may be caused can be ameliorated by the powers of this court at the level of remedy. This court can grant a retrospective order. So that deals with irreparable harm. The balance of convenience is probably, we respectfully submit, where the applicants are weakest, save for the prima facie right. And that again goes back to our joinder point, which I won't belabor. The applicants say that the balance of convenience favors them, but the organs of state are not here to explain what inconvenience would be caused if it were to happen that these regulations were suspended in the interim. And one can assume that there would be great inconvenience. And this is something that the applicants fail to address at all in their pleadings. The prospect of prejudice that may arise if the applicants are successful with their interim application, and then if the minister is ultimately successful with the main application. And that would be, of course, because there would be a lacuna, a gap in time during which organs of state would presumably be awarding tenders, but not subject to the regulations, which this court would then find on this hypothetical scenario to be valid. In those circumstances, there's no plan, no pleading, and no statement as to how that prejudice, the rollback, will be ameliorated. And we submit that that cannot be answered. And that being the case, there would be potentially literally chaos as regards tenders. And this court is left none the wiser, most importantly, because the organs of state are not here to say their piece. Alternative remedy, we've respectfully submitted that a retrospective order would be an effective alternative remedy, and I won't waste any more of the court's time on that. There is one more issue that I should address under Prayer 5, which is the discretion of this honorable court. It is trite, of course, that interim interdicts, even if the legal requirements are established, always remain discretionary, always remain within the discretion of this court. And an interim interdict, interdicting the application of a law that has to do with public procurement, we respectfully submit, has not been shown, it hasn't been shown that this is one of those cases that this court, as a court of first and final instance, should exercise its discretion. So even if we were wrong about everything on the merits, we would still respectfully submit that in this court's discretion, the interdict in Prayer 5 should be declined. So that then is the entirety of the applicant's application. That's the entirety of the substance of the applicant's application, the substantive relief that they seek. The remainder of the relief is ancillary relief or is gateway relief. I'll clarify what I mean in a moment. Moving to Prayer 1, the question is, has the applicant established urgency? Now, Prayer 1 would obviously be this court's first port of call in terms of deciding whether to consider the merits or not. I deal with it last because we submit that there cannot be any urgency established in respect of what we submit as a stillborn application. And that's the first reason that we submit that there's no urgency. But the second reason we submit that there's no urgency is that we respectfully submit that this is a clear case of self-created urgency. The applicants provide no explanation for why they waited until a month ago, save to say in their founding affidavit that there was no way they could have known what impact the regulations would have had before they were put into effect. We respectfully submit that clearly there was a way that they could have known, and that this court can comfortably reject that submission as a basis for waiting until the 11th hour to approach the court. It's trite, and we've covered in our written submissions that self-created urgency won't be rewarded. And we would respectfully submit that that applies even more strongly in this court as the highest court. This is not a court that's well suited to determining factual disputes, with the greatest of respect. So that means, in our respectful submission, that the application is either not urgent or it is urgent, but the urgency is self-created. But in either event, we respectfully submit that the application doesn't meet the mark on Prayer 1. So no urgency. Prayers 2 and 3 are direct access and intervention. And justices, we've addressed these in our heads of argument. We respectfully submit fairly comprehensively. The key points are that the test is the same. It's the interests of justice ultimately. And we submit that there can be no interest in allowing the intervention or the direct access of applicants to advance new facts that are untested before this court, intervening in a matter with new facts in regard to a question of law, which is an objective inquiry. Neither requirement can be met given the submissions that I've respectfully advanced up to this point. And if that's so, then we only have one prayer left, which is costs. Unlike as regards the main application, under prayer 7, we respectfully submit, firstly, not that costs should be granted to the applicant, but in fact, that in this instance, the minister should be furnished with his costs. And we say that because we respectfully submit that the BioWatch rule does not apply in this instance. It doesn't apply in this instance, we submit, because it's very clear from the applicant's founding affidavit and their replying affidavit that the actuating intention of their application is to ensure that they secure their own financial gain. It is not an application that's brought, as with Afribusiness, to determine a vexed issue of public law. It's an application to ensure that the applicants are able to get as many tenders as possible in the interim period between now and the main application. And so we submit that in those circumstances, the BioWatch rule does not apply. And for that reason, we respectfully submit that costs should be granted in the minister's favor. And that then leaves me at an end of my exposition on the applicant's notice of motion, Justices. Unless Justices have any questions for me, those are my submissions in regard to the interlocutory application.
Thank you, Mr. Stubbs.
Thank you, Acting Deputy Chief Justice.
Mr. Scasboto.
Thank you very much, Acting Deputy Chief Justice Kampepe, the Justices of the Constitutional Court. I must say I had to go through my notes and remove quite a bit of substance that I'd meant to deal with, because most of it was traversed in the debate between counsel for the applicant as well as the justices of the court. With that being said, I still have a couple of points to make. Perhaps I won't be as long as I would have been initially. The EFF intends on making 4 very brief submissions. The very first is the historical and constitutional context within which this matter locates itself. I'm not going to be long on the theory, but I feel, well, it would be prudent, I would imagine, to draw the constitutional premise upon which 217.2 finds meaning. In so doing, then it becomes that much easier to understand the context and the scheme of the Act and the regulations that stem from Section 217.3 of the Constitution. The second issue I will address on behalf of the EFF is the finding of the Constitutional Court, which we've dealt with quite extensively, which is what I'll refer to as the pre-qualification finding. And I'll make submissions as to why the SCA with respect misdirected itself in that regard. Thirdly, I will deal, and related thereto, I will deal with respect the misdirection I submit of the Supreme Court of Appeal in finding that the Framework Agreement does not, the Framework Act does not provide for preliminary disqualification. Again, that point has been covered quite extensively, but nonetheless, I would like to make a point or two in that regard. And that is what I'll call the ultra vires finding for brevity purposes. And finally, as a fourth point that I will deal with is the question of the Supreme Court of Appeal finding that the antecedent step is not introduced in legislation in terms of Regulation 4. And an additional layer rather was created, which is not permissible in terms of 217 of the Constitution, as well as the Framework Agreement. So those are the 4 themes that I'm going to deal with quite briefly. And with that being said, I'm going to deal with the very first aspect, which is the issue of the historical and constitutional context of the matter we are currently seized with. And the submission I make in this regard is that to properly appreciate the context in the scheme of 217.2 specifically, one must have regard to the preamble of the Constitution. And I'm not inviting the justices to go there, but just to make note of what it says, that we, the people of South Africa, recognize the injustices of the past. And we therefore, through our freely elected representatives, adopt this constitution as a supreme law of the republic, so as to, importantly, heal the divisions of the past and to improve the quality of life of all citizens. Now, that is a framework upon which 217.2 finds meaning. And once you understand that link between 217.2 and the preamble, it then becomes easy to understand the context in which the Section 217.3 Act, Framework Act, finds meaning. And I thought, just for context purposes, it's a point worth making. And again, without exhausting time on this point, I make reference to the finding of this court in Tshwane Municipality versus AfriForum in BCLR 1133 Constitutional Court at page 4, where the Constitutional Court made the point that colonialism and apartheid is a system so stubborn that its divisive and harmful effects continue to plague us and retard our progress as a nation more than 2 decades into our hard-earned constitutional democracy. Now, that's the framework and the context within which I'm inviting this court to understand and interpret Section 217 as well as the regulations. Now, getting to the substantive matter of my submissions, I'm going to deal initially with the question of the pre-qualification question. And perhaps as a starting point, I invite this court to bear in mind that whatever, and this comes about as a result of the debate between the counsel for the applicant as well as the justices. It is worth reminding the court that whatever the hurdles may be, interpretative hurdles in terms of how we get to the regulations, this constitutional court's jurisprudence is such that we must avoid any interpretation that does not find a solution within the scheme. In other words, the act as it is provided, as well as the regulations, the Constitutional Court, the principle goes, must read them in such a manner such that it does not find them to be unconstitutional. Specifically, I'm making reference to Section 2.1, the 2.1 debate, as well as how the determination is made in terms of whether there should be pre-qualification or not. In this regard, I again make reference to how the regulations came about. Perhaps this should be my starting point. The regulations themselves come about as a result of Section 5.1 of the Act, which in itself comes about as a result of 217.3 of the Constitution. The point I simply seek to make there is to make a determination as to whether the regulation is unconstitutional or not. One must ask the question, what does the Act provide? In other words, does the scheme of 4.1, specifically in the regulation, align with the scheme of the Act? My submission is yes, it does. Basis 2.1 of the Act itself, as well as 5.1 of the Act, because the Act provides in very broad terms the powers of the minister in relation to making regulation. It speaks about efficiency, it speaks of expediency, it speaks about necessity. And again, invite this court to consider its own jurisprudence on the wide discretionary powers that are given to the minister in this regard. And then the secondary question becomes, well, the Act itself, where does it source its power? It sources it from 217 sub 3. And 217 sub 3 is nothing other than a provision that provides that 217.2 agenda, I will call it, is given effect to. What does 217.2 provide? Very broad powers. Specifically, it says nothing in subsection 1 of 217 inhibits the attainment of the policy and the objectives of 217.2. I suggest that is a broad enough power to cure whatever shortcomings, and I submit, perhaps let me do this cautiously. My submission is that there are any efficiencies with the Act. The point I simply make is the Constitutional Court, in determining the questions before it, must bear in mind the framing of 217(2), which provides that nothing under sub 1 prevents any organ of state or institution from implementing any procurement policy for the advancement of the disadvantaged persons. So it is within that context and that framework.
Mr. Kaspoto, your protection time has expired.
Thank you, Acting DCJ. So the point I simply make in that regard, Justices of this Court, is that the scheme stemming from 217 sub 2 of the Constitution.
Mr. Kaspoto,
yes, Justice
dealing with or touching on Section 5, you cross-referred to Section 2. Does that mean you see a correlation between the two sections or not really?
The answer, Justice Madlanga, is yes and no. Perhaps let me start by explaining how we see 2 and 5. 5 is nothing other than a provision that empowers the minister to make the regulations. It is structured in such broad terms, and you can understand why, at least we can understand why it's structured the way it does. It is simply to give effect to 217(2), and the wide discretion is given to the minister in that regard. Now, if you are going to have a procurement policy which targets certain individuals as defined in the regulations and the Act, this is a scheme within which you will do it. That's how we understand 5.1. It only gives effect to the regulations. 2, on the other hand, is a scheme by which an organ of state will determine its procurement policy, step 1. Having so determined the procurement policy, it will implement that policy within the framework and the scheme of 2. As we understand it, Justice Madlang, and I suppose this is where you're taking me to, the regulations itself are nothing more than what will inform the determination made by the organ of state in question. Now, I don't want to go to the plenary powers debate. The point I simply make is this: using whatever instrument the organ of state in question may use to pre-qualify, they will have regard to the scheme of 2 as well as the regulations. The determination in terms of 2 will be made in whatever instrument, let's call it the tender document itself, where we say in terms of 2(1)(e) of the Act, this is the goal we seek to achieve. For that reason, these are the categories of people we're going to target. And of course, it's a logical provision to have if you want to attain the goals of 217(2). Because what is the point? We would submit it would be absurd to say we are targeting Black females, for example, and then there's no pre-qualification mechanism. The essence of it would be A, B, and C, who clearly do not qualify, would submit their tenders. And once their tenders are submitted, only then the determination is made. We would submit that leads to absurdity. If 2(1) itself says you may determine your policies, there is no reason why you can't say on the basis of this policy, these are the people we seek to target. And if that is what you do, in essence, that's a pre-qualification empowered by 2(1).
Okay. So pre-qualification is possible in terms of 2(1).
I submit.
Just like you would say, because of the breadth of 5, it would be possible under 5 as well.
That is my respectful submission, Justice Madlanga. They are both crafted in such broad terms that discretion is given to the organs of state as well as the minister in terms of what policies they want to follow. And if that policy is pre-qualification because you want to attain the goals of 217(2), those are powers you have in 2(1) and 5.
And why would the Act do this twice then? if it's possible under 2, why would it also make it possible under 5? Isn't that a reason for reading 5 restrictively?
It could well be, Justice Madlanga, and I need to be careful here.
I saw Mr. Mainecho was very careful not to come anywhere close to section 2 with regard to his reading of 5. Yes, please.
Yes. Justice Madlanga, the point I'm simply making is this. As I understand 2.1, it says the organ of state must determine its policy and implement it in terms of this framework. In terms of that framework, we've got 2.1e, which says these are the goals. One of the goals is to specifically target a specific group so as to redress the unjust, or rather the unfair discrimination. That's the wording of 2.1, and you can't interpret it otherwise. For that reason, I make the submission that read into that is a pre-qualification standard. You can't get to these are the groups we are targeting at the same time, not have a pre-qualification. It's absurdity, I submit. 5.1, on the other hand, is a provision that gives effect to the impugned regulations. And in terms of that scheme in 4.1, the minister in his wisdom has made that listing, i.e. those qualifications. As I would understand it, how it would work practically speaking, the organ of state in question would have regard to the provisions of 4.1 in determining its scheme, i.e. its policies. And once that policy has been determined by the organ of state in line with the regulation, it then implements the provision, or rather the policy that it would have adopted. That would be my submission, Justice Madlanga.
Thank you, Mr. Kasbotu.
Mr. Kasbotu, again, as Justice Madlanga has just pointed out, I fail to see why you don't find a correlation between 5 and 2, sections 5 and 2. Let's go to section 5. Isn't it that the wide power the minister is given to make regulations on matters that are necessary or expedient? The purpose is to achieve the objects of the Framework Act. Is it that not correct?
Indeed, so Justice Chaft.
And where else in the Framework Act would you find its objects except in 2?
Indeed, so Justice Chaft.
So is there no correlation?
Well, the correlation is there, Justice Chaft. To make the point clear, my submission is not that there are 2 freestanding provisos in the Act. All I'm simply saying is the section 2 proviso, or rather framework, is a framework that is directed towards the organs of state internally. So if ESCOM wants to have a procurement policy within its own systems, they are empowered in terms of section 2.1 to come about, or rather to bring about those policies, those preferential policies. 5.1, on the other hand, is broader than that, in a sense that it is regulations that are all-encompassing, in other words, covering aspects beyond just ESCOM. And all I'm simply saying is then the minister, in his wisdom, has come up with the criterion he's come up with in terms of 5.1.
Can the minister, in making regulations, make regulations which are intended to achieve something other than the objects of the Framework Act? Why as it is?
Yeah, the difficulty is this, Justice Jafta, with that proposition. 2.1 itself is not exhaustive. The question, I imagine, is premised on an idea that there's a finite 4-cornered proviso of what 2.1 is. All 2.1 is a framework. It is not an all-encompassing proviso of what can and cannot be done within the 4 corners. 5.1, on the other hand, is broad.
If you are to determine whether a regulation made by the minister is meant to achieve the objective of the act, you'll have to go to 2, isn't it?
Indeed, Justice Jaffe.
Even if it may have, it may be a situation where what the regulation seeks to achieve would be in line with section 217 sub 2. But if it doesn't seek to achieve the objects of the act, one may argue that it is ultra vires because section 5.1 itself says the minister must make regulations on matters which are expedient or necessary in order to achieve the objects of this act. Isn't that correct?
It is so, Justice Jaffe.
Okay.
Indeed so. It's so, Justice Jaffe.
So, if my brother's done, are you saying that by virtue of regulation of section 5 and the breadth of that provision where the minister can make any regulations, it's possible for the minister to make regulations that would include a category such as people with a particular socioeconomic status, which would be something not included in the Act, the Framework Act. So it's outside of the Framework Act. Are you saying that's possible through regulations?
The first qualifier, Justice Pillay, to your question is that insofar as you make the point that the regulations would envisage individuals of a certain socio-economic standing, provided that grouping is suffering from unfair discrimination to begin with.
Take that as given. Yeah.
Okay. So with that qualification, Justice Pillay, the answer must be yes. And the simple reason for that is 2.1 itself is not exhaustive. It's something different if we've got a crystallized list of individuals and goals. In other words, goal A, B, and C. Then of course 5, or rather regulations in terms of 5.1 cannot go beyond that. My submission is this: 2.1 is not finite. 5.1 is crafted in broad terms. It gives discretion to the minister for expedience and necessity to come up with a criterion. And the idea there is simple. 217.2 provides that nothing under 1 will inhibit whatever policy goals, provided of course they meet the legality test, will inhibit the minister from making regulations that cover categories outside of what 2.1 itself provides. So again, being very careful, I'm not suggesting for a minute that the minister can go over and above what is provided for in the Act. All I simply am saying is that it can cover individuals provided they suffer unfair discrimination and they fall within the framework of 2.1.
So it is referring to the words may include in D, and which generally anticipates but not limited to. Is that the basis on what you're saying, that section 2 is not limiting?
That is my submission, Justice Pillay.
Thank you.
And as a concluding remark, Justices, Acting DCJ, I may or may not have gone beyond 15 minutes. Please bear with me. I promise to not take more than a minute of your time. And my last submission is in relation to the 4th point that I alluded to earlier, which is the regulatory additional layer finding that was made by the Supreme Court of Appeal. And this appears at page 21, paragraph 43 of the SCA decision. And the finding there, it says the minister may not make regulations regarding any matter, or rather, sorry, 5.1 is the provision that we've just dealt with now, which is expedience and the necessity power of the minister in relation to making regulations. And my submission there is simply this: the additional layer that the Supreme Court of Appeal is talking about is nothing either or outside of what 5.1 says. Again, that wide discretionary power, because all it simply says, notwithstanding everything else in the Act, for expedience and necessity to achieve the constitutional objects of 217(2), which go to the core of our constitutional order, which is the redress of past injustices, the minister is correctly given this power to go, or rather to have a discretionary that is not hinged or limited by technicalities, but rather given powers so wide, reasonably and rationally wide, to give effects to the objects of 217(2). So our submission is simply this in this regard. Regulation 4 is nothing other than an exercise or the product of 5.1 discretionary powers of the minister, nothing more, nothing less. And as a concluding remark in this regard, we invite this court to bear in mind, firstly, as I've alluded to earlier on, the need to read the text in a manner such that it accords with the intentions of the legislature, and to not, with respect, whimsically find inconsistencies in an act that, for one, clearly gives wide powers to the minister. It has wide-ranging empowering provisions from the Constitution, wording to the effect of nothing will prevent the attainment of 217(2) on the basis of 217(1). And if the justices of the court have no further questions, I'm indebted to this court.
Thank you, Mr. Kasiboto.
As a court, please.
Mr. Bergentine.
May it please the court, justices. Justices, may I, as an introduction, refer to the introductory words of Acting Deputy Chief Justice Kompepe in the matter of Free State Province versus Welcome High School and other school, where the question was whether the head of the Department of Education could interfere with pregnancy policies adopted by governing bodies of schools. And in that matter, Acting Deputy Chief Justice Kompepe said in the first paragraph, state functionaries, now no matter how well intentioned, may only do what the law empowers them to do. That's in essence the principle of legality, the bedrock of our constitutional dispensation, and has long been enshrined in our law. That's the principle upon which the respondent relies for supporting the judgment of the Supreme Court of Appeal. And the same sentiment was echoed in the matter of Sanral versus Cape Town City, to which we've referred at page 22 of our heads of argument, when it was said, what is clear, however, is that the Transport Minister is constrained to make decisions in accordance with statutory prescripts. As stated above, it is now accepted as elementary that the exercise of public power is subject to constitutional control and is clearly constrained by the principle of legality. A repository of power may not exercise any power or perform any function beyond that conferred upon it by the law, and it must not misconstrue the nature and the ambit of the power. And the case made out by the respondent from the date that the application was launched in the court of first instance was that the minister did not have the power to make regulations which require or allow pre-qualification criteria on the one hand, and on the other hand, which allowed or required for subcontracting in certain instances, as we find in Regulation 9 of the 2017 regulations. So the real question in this matter is, did the minister have the power to allow pre-qualification criteria in terms of tenders and or tenderers, it would be better to state. And in the second place, did the minister have the power to regulate for compulsory subcontracting in certain instances? And to answer that question, one must have regard to the empowering legislation. The empowering legislation, there's no doubt about, is Section 217 of the Constitution on the one hand, and on the other hand, the Procurement Act, or the PPPFA as it is called. Now, firstly, 2171 of the Constitution refers to the 5 objectives of procurement and refers to a system which must be followed, which is fair, equitable, transparent, competitive, and cost-effective. Then in subsection 2, we have an indication that subsection 1 does not prevent organs of states or institutions referred to in that subsection from implementing a procurement policy. We're not with a system any longer, we're now with a procurement policy providing for A, categories of preference in the allocation of contracts and the protection or advancement of persons or categories of persons disadvantaged by unfair discrimination. What is important of 2172 is the indication that subsection 1 does not prevent. The indication is not the objectives of subsection 2171 are not relevant if we are dealing with discriminated against persons. And then, of course, we have 2173 stipulating national legislation must prescribe a framework within which the policy referred to in subsection 2 must be implemented. So the framework must prescribe policy. From there, we must move to the Procurement Act itself. The Procurement Act, which prescribes in section 2 the framework. So it is important that to give effect to 2173 of the Constitution, we must have regard to section 2 of the Procurement Act. And what does the Procurement Act prescribe? The Procurement Act prescribed first a preference point system. There must be a distinction between lower level and higher level contracts. We know that 80 or 90 points may be allocated to price, 20 or 20 points may be allocated to specific goals. And then specific goals in terms of 21D may include contracting with persons or categories of persons historically disadvantaged by unfair discrimination on the basis of race, gender, and disability, and further implementing programs of reconstruction. So if one has regard to section 2, where we find the framework prescribed as envisaged in 2173, The one thing that is clear is that there's no indication in section 2 that there may be pre-qualification. And I followed the debate between counsel for the minister and the justices, where reference was made to a determination stage and the implementation stage. But the answer to that debate appears to be that in terms of the framework that we find in the Procurement Act, section 2, no provision is made for a determination stage. Or put in other words, no provision is made for pre-qualification of tenderers to first establish a specific group of tenderers and thereafter to proceed to apply the further requirements of the framework. What is also of importance is, if we have regard to 2173, is that the very specific indication is that national legislation must provide for a framework. Not the Minister of Finance must provide for a framework. It's national legislation. So if we want to establish what the framework is, we must see what we can find was established by legislation.
Mr. President, if I may just interject here and request that the court adjourns for 5 minutes.
May it please the court, Acting Chief Deputy Justice Compare.
The court is adjourned for 5 minutes.
Thank you, Acting Deputy Chief Justice. Court will adjourn until 12:40. Please note that during the adjournment, you are welcome to switch off your video and mute your microphone, and then rejoin with video and sound when the hearing recommences at 12:40. Should you exit, you may use the same link to rejoin the hearing.
Mr. Kobe.
Acting Deputy Chief Justice. I think we are just awaiting Justice Jafta to rejoin. Acting Deputy Chief Justice, Justices of the Constitutional Court, all counsel are online.
Thank you, Mr. Kobe. Mr. Bergentine.
You Justices. Justices, as introduction, I indicated that what must be established in this matter is whether the power was conferred upon the minister in this instance by Section 217 of the Constitution on the one hand, and the Procurement Act on the other hand, to allow for pre-qualification criteria where tenderers may be pre-qualified on the one hand, and on the other hand, whether he could have required for compulsory subcontracting in certain instances. To establish that, we must have regard to 217(1), 2, and 3 of the Constitution, read with the Procurement Act, more in particular Section 2 of the Act. Now, there must be an harmonious interpretation of the legislation. One cannot separate Section 2172 and say if Section 2172 applies, it is not necessary to have further regard to the objectives of procurement mentioned in 2171. And for that reason, we submit that the criticism against the SCA judgment, when it was decided that the procurement regulations were indeed in conflict with the objectives we find in 2171, cannot be proper. Furthermore, it is important that the principle to be extracted from the empowering legislation we submit is this: all suppliers may tender for government contracts. And we are fortified in that submission if we have regard to Regulation 6.4 and Regulation 7.4 of the 2017 regulations. Now, in terms of both those regulations to which reference has already been made, it is stated, a tenderer failing to submit proof of BBBEE status level of contributor or is a non-compliant contributor to BBBEE may not be disqualified, but may only score points out of 80 for price and score 0 points out of 20 for BBBE. That's in the case of lower level contracts. And of course, then such a non-compliant tenderer may not score 10 points in the case of higher level contracts. Now that is clearly, that stipulation in regulations 6.4 and 7.4 cannot be reconciled with regulation 4, where pre-qualification criteria are allowed inter alia relating to the BEE status of a tenderer. There has been an attempt to reconcile these conflicting versions, and that we find in the guide, implementation guide of the 2017 procurement regulations in volume 10, and I refer to page 944, where the following is stated under 9.2. Tenderers who do not submit BBBEE status level verification certificates or who are non-compliant contributors to BBBEE do not qualify for preference points for BBBEE, but should not be disqualified from the tendering process. They will score points out of 90 or 80 for price only, and 0 points out of 10 or 20 for BBBEE. That is basically regulation 6.4 and 7.4. But then in 9.3, it is indicated, however, should institutions stipulate a specific BBBEE status level as pre-qualification criteria in terms of regulation 4, and the tenderer does not meet this requirement, institutions must disqualify such tenderer as having submitted an unacceptable tender. Now, this is again then regulation 4, but the two is still in conflict. And the clear indication is that the principle is all suppliers may tender. Why do we still find regulation 6.4 and 7.4 in the regulations? Because those regulations are basically repeated from the 2001 and 2011 regulations, where the principle was clearly stated: all tenderers, all possible suppliers are allowed to tender. The only possible exception to the rule is 2.1F of the Procurement Act, which provides, firstly, that the highest point scorer must be awarded the contract, with one exception if there are objective criteria over and above in addition to the specific goals mentioned in 2.1D. So the clear indication there is objective criteria may not include previously disadvantaged status of tenderers.
Mr. Bergentine, your protection time has expired.
Thank you. I appreciate it, Deputy Chief Justice Pepe. Yes. Justice Mawanga.
Yeah, thank you. I'm interested to know if pre-qualification would not fall within the ambit of section 2, or that is the ambit of categories of preference as envisaged in section 2172A. 2172A, categories of preference.
That's in the regulation, the PPPFA itself.
No, I'm talking about the Constitution. Sorry,
Constitution, yes.
Section 217, sub 2, paragraph A. Would pre-qualification not fall within the ambit of open quote categories of preference?
Yes, my submission in this regard, Justice Matlanga, as I've indicated, is we cannot separate the interpretation of the Constitution from interpretation of the Procurement Act itself, because the Constitution and the Procurement Act must be read together.
You can't use an act of parliament to interpret the Constitution, Mr. Bergantine.
No, but the Constitution itself stipulates in 2173 that the procurement policies provision must be made for the framework within which procurement policies must be accepted by state organs of state.
Yeah, the act is a product of Constitution says, what 2713 says, of course, 3 referring back to 2, so we must look at 2. So the product of that. Now, to be able to anticipate what the act should provide for and what it should not provide for, we must look at the source being the Constitution. So it is on that basis that I want us to focus at the Constitution now, because that is what is going to tell us what the Act must provide.
Yes.
Coming back to the Constitution, would pre-qualification fall within the ambit of open quote, categories of preference, close quote, or not?
Yes, well, I must concede it must fall within pre-qualification, must fall within categories of preference in the allocation of contracts. So that is allowed in terms of 2171(2)(b), that there may be categories of preference in the allocation of contracts. But then we must further have regard to the Procurement Act with respect, Justice Matlanga.
I don't understand that.
No,
I honestly don't understand that. I'm repeating myself, and I say again, it's a standing constitutional principle that you cannot use an act of parliament to interpret the Constitution. And I'm still focusing at the Constitution. So I do not see why, when we are still at that level, you keep drawing me to the Act of Parliament. In fact, this is not something new. It's not just about constitutional interpretation. Even with regard to ordinary acts of Parliament, you cannot, for example, use regulations made in terms of an Act of Parliament to interpret the Act of Parliament. So its basis is not a new principle. Now, if in terms of section 2172, the idea is to protect or advance persons or categories of persons disadvantaged by unfair discrimination. And this provision is prefaced with the words, subsection 1 does not prevent organs of state from creating these categories of preference. Does it not make nonsense of what this subsection, that is subsection 2, seeks to achieve, to then subject it to the very subsection that it says, it being subsection 2, it says, whatever subsections 1 may be saying, organs of state, you are free to create categories of preference in order to protect or advance previously disadvantaged persons. Does it not make nonsense of that to then subject that very provision to subsection 1?
Maybe I can explain it like this, Justice Matlanga. The argument on behalf of the respondent was throughout. It was not for the minister to interfere and to legislate and to enlarge the framework which the legislature prescribed in the Procurement Act. And if you are correct,
that is a different point, though. That is a different point because
that's the point that we made throughout.
You make that point, but you also make a different point, which is that the creation of the categories is a non-starter in the face of subsection 1.
No, we do not.
So it is just this that I'm testing now. Just this.
Yes. We've always said that the Constitution allows for previously disadvantaged individuals to be preferred. That we cannot dispute. But we must, how they are to be preferred was left to the discretion of the legislature. And the legislature determined in terms of the framework in section 2 of the Procurement Act that PDI status should be taken into account as part of a preference point system. And points for specific goals should be allocated to previously disadvantaged status. That was what the legislature did. And if we have regard to what the Supreme Court of Appeal did, if I may refer to volume 9, page 932, part of the judgment. What the Supreme Court of Appeal did, there we find the order. The result, I'm making the following order. The appeal is upheld with costs. The order of the court a quo is set aside and replaced with the following order. The application succeeds with costs. It is declared that the Preferential Procurement Regulations 2017 are inconsistent with the Preferential Procurement Policy Framework Act 5 of 2000 and invalid. Not inconsistent with the Constitution. The order of the SCA specifically declares the regulations inconsistent with the Framework Act. And that is the argument on behalf of the respondent, that the Framework Act, which followed upon 2173 of the Constitution, does not allow for pre-qualification criteria. But the minister, in his wisdom, decided that there should be pre-qualification criteria. We submit in terms of the Framework Act, and that's the section 5 thereof is the relevant section which empowered the minister to make the regulations. We say he could not, because of the principle of legality, make regulations in conflict with the Procurement Act, as was found by the Supreme Court of Appeal to be the situation.
Mr. Burgenton,
Yes, Justice Jafta.
Let's look at section 2(1)(d). Do you accept that it permits the inclusion in the procurement policy of unidentified specific goals?
D, which specifies the specific goals may include.
Yeah.
Yes. That specific goals refer back to the specific goals which we find in B sub 1 and sub 2, where reference is made that for contracts with a rand value above the prescribed amount, a maximum of 10 points may be allocated for specific goals as contemplated in paragraph D. So specific goals may...
Why do you say it refers back to 1A and B? Well, why do you say so?
Because specific goals is defined or circumscribed in 1B or B1 and 2 to allow for 10 or for 20 points as part of 100 points.
No, I don't understand that argument. We're talking about policy, aren't we? We're not talking about scoring of tenders that have been submitted. We're talking about policy. D says the policy may include specific goals, which may include the listed ones.
Yes.
And if so, the unlisted ones, where would they be reflected? To inform prospective tenderers that there are also these goals which are meant to be met by the tender. If they are not to be contained upfront in the policy, where would they be mentioned?
Well, the answer to your question, Justice Jafta, is twofold. If we have regard to the 2001 regulations.
Now you're going to do what Justice Madlanga just warned you not to do. You want to interpret the act by using regulations.
Now, what I want to do is to point out that in the 2001 regulations, specific goals was listed. Various specific goals. There were specific goals from A to K listed. So there the minister, in his wisdom, made a list of specific goals. But he did not do so in the 2011 and in the 2017 regulations. So there may be specific goals in terms of E. Those goals must be clearly specified in the invitation to tender. But the important aspect with respect...
Can I interrupt there, Mr. Beganthen, because that is the part of the act which makes it clear that specific goals may be made upfront, mentioned upfront. It says in the tender documents. Now, why should the same goals not be mentioned in the policy? For them only to say, in terms of the act, it is only permissible for them to be mentioned in the tender documents. If you mention them in the policy, you're acting contrary to the act. But if you mention them in the tender documents themselves, then you comply with the act.
No, surely specific goals may be mentioned in the policy. But
they may be mentioned.
Yes, but the important aspect, my Justice Jafta, is that specific goals are limited in terms of 1B with a specific cross-reference to 2D, that only 10 or 20 points may be allowed for specific goals. So it cannot be argued that specific goals may first serve as qualification criteria, and thereafter again 10 or 10 points may be allocated for specific goals, because the first requirement is that an organ of state must determine in its procurement policy and implement the following framework. A preference point system must be followed.
What you are saying actually speaks to the implementation. It doesn't speak to the determination of the policy. And I understand your concession to be that specific goals may be included in the policy. So there's nothing in the Framework Act which prohibits the mentioning of specific goals upfront in the policy. They may be mentioned, but what you are saying is that once you have done that, when you are implementing the tender, evaluating the tenders, for those specific goals, you can't award more than 20 points. That's a different point. The issue that we were dealing with is whether or not the minister had power to make regulations which allow the mentioning of specific goals in the policy.
Well, all that I can reply to that, Justice Jafta, is that a specific weight is to be attached to specific goals in terms of 21D. And we cannot get past that. So the minister cannot, by allowing pre-qualification criteria, circumvent or take a detour around the specific goals and the points to be allowed for specific goals in terms of 21D.
So on your interpretation, organs of state, even where they know that they're not going to award a tender to any tenderer who does not fall within the previously disadvantaged persons, even if they know that upfront, they should issue tender invitation to everybody. Let everybody submit tenders, spend money in preparing their tender, submit a tender, and when it comes to evaluating tenders, say, well, we did not intend to give this tender to people who are not within the category of previously disadvantaged persons, and therefore we will consider only those who qualify in terms of that category. Is that the interpretation that we should adopt of the Act?
Well, in my submission, Justice Jafta, the indication by the framework is this: a state organ cannot, before applying the preference point system, decide that only certain tenderers will qualify and certain will not qualify. There is simply no provision made for that in the PPPFA. And if I may refer to the Broad-Based Black Economic Empowerment Act, there we find such a provision. If I may refer, Broad-Based Black Economic Empowerment Act, in section 9, 1B, the following is allowed. And remember that the relevant minister there is the Minister of Trade and Industry, not the Minister of Finance, as in our instance. Section D deals with the codes of good practice and stipulates, in order to promote the purposes of the Act, the minister, by notice in the Gazette, may issue codes of good practice on Black economic empowerment that may include -B, qualification criteria for preferential purposes for procurement or other economic activities. So in the BBBEE Act, there's specific provision for qualification criteria, which is an indication that the legislature was alive, that there must be a specific stipulation to allow for qualification criteria. That is absent in the case of the Procurement Act. And for that reason, the argument is there is no pre-qualification criteria allowed for in the Framework Act. May I say this, Justice Madlanga indicated that the legislature could have been more direct to achieve 2172 or the purpose of 2172 in the Constitution. And of course that is true. But the whole argument on behalf of the respondent is this: if there had to be an amendment of the Procurement Act, it was for the legislature to make the amendment, not for the minister. And that was borne out by the task team with its discussion paper, where the indication was that there should have been an alignment between the Procurement Act and its regulations and the various BBBEE legislation. But that was then not done. It was done by the minister, who attempted to take a shortcut and make regulations to actually enlarge the framework which we find in the Procurement Act, which he could not have done in terms of the principle of legality.
Do you accept, Mr. Burgenthein, that because here we're dealing with legislation that gives effect to the Constitution, the approach to interpretation to that legislation must be the same as the approach to the Constitution? That is, it must be given a generous and purposive interpretation.
Indeed so, Justice Jafta.
So the issue of the example of the other act that expressly say there could be pre-qualification made would be an interpretation that follows the strictly the grammatical meaning of the act without looking or making room for the generous and purposive interpretation. Isn't it so?
You know, we do not say you must only look at the grammatical meaning. Of course, you must also look at the further objectives and the context. But in his wisdom, or its wisdom, the legislature allowed for 10 points and 20 points to be allocated to previously disadvantaged status. And that we find in the Procurement Act.
And that happens. Again, it takes us back to the earlier debate that Justice Madlanga had with Mr. Maneji. That really happens when one implements, when one looks at the tenders, say the tender invitation had no exclusion. Everybody had tendered. And now you are evaluating each and every tender and scoring it. Then you will do exactly what you are saying.
The point we are making, Justice Jafta, is that there is no room for pre-qualification within the confines of the Procurement Act. So the upshot, and we have indicated that there are many authorities confirming this, is that we are basically dealing, if we deal with procurement, with a two-stage process. The first stage is there's a points education, and that's done on price and previously disadvantaged status. And thereafter, there's a question whether there are objective criteria in addition to special goals, which justifies the award of a tender to not the highest tenderer, scoring tenderer. That's a two-stage process. The court of first instance and the minister, they say no, we are actually dealing with a three-stage process. First, you must determine what is an acceptable tender. And acceptable tender is defined in the Procurement Act itself as a tender complying with the conditions and stipulations of the tender. Now, we've indicated in our heads of argument that those references to conditions and stipulations of tender are indeed references to the form and the content of the tender, not to the tenderer as such. To qualify the tenderer cannot be justified with the definition of acceptable tender. And that is further borne out by the definitions of tender that we had in the previous iterations of the regulations. Firstly, the 2001 regulations, which you will find in volume 2, page 167, where a tender was defined as the following. A tender means a written offer or bid in a prescribed or stipulated form in response to an invitation by an organ of state for the provision of services or goods. And then in the 2011 regulations, a tender was defined as follows. A tender means a written offer in a prescribed or stipulated form. So it's all about form and content. In response to an invitation by an organ of state for the provision of services, works, or goods through price quotations, advertised competitive tendering processes, or proposals. Now, significantly enough, and it was necessary for the minister because there was now pre-qualification criteria, and if not complied with, the stipulation in the regulations is that it will not be an acceptable tender. The definition of tender, as we had in the 2001 and 2011 regulations, has simply fallen away. There's no further definition of a tender. But the authorities also indicate that acceptable tender, which must comply with conditions and stipulations of the tender, indeed refer to content and form. Reference was made by us to the matter of Dr. J.S. Maroka municipality, where the relevant condition which rendered the tender unacceptable was that an original SARS document was not annexed to the tender. In J.F. Sapela, the relevant tenderer refrained from tendering for a specific part of the work, and therefore it was an unacceptable tender. So,
but Mr. Beckenton, if the whole exercise is about protection and advancement of tenderers from certain groups in terms of section 217 sub 2. Why do you say that the description of the tenderer is not material?
No, but we do not find the definition of tenderer in any of the regulations or in the Act.
No, but
we cannot
remember where you started with Justice Madlanga. You considered that the purpose of Section 2172 is to protect and advance persons from the previously disadvantaged groups. No, not tenders, persons. That you conceded. Now, I'm not quite sure it is helpful, the issue of belaboring the question of what a tender means and all that, when we know that the Act was passed in order to give effect to subsection 2. It says so expressly in the long heading of the Act.
2173, yes.
So the Act is designed to protect those who were previously disadvantaged.
But if there were defects in the Act, or if there are defects in the Act,
in our interpretation, shouldn't then our interpretation be directed at realizing the purpose of the Act?
But still, we cannot deny the wording of the Act itself, Justice EFFA.
I accept that. I accept that. But where the language is reasonably capable of a meaning that achieves the purpose of the Act, and there's another meaning which does not achieve that purpose, we have to prefer the meaning that achieves the purpose, isn't it?
But the submission of the respondent is that there is no possibility that the Act may mean that there could be or that there can be pre-qualification criteria. And we are supported in that. Reference has been made to the Supreme Court of Appeal judgment in Airports Company of South Africa versus Imperial. What happened in that matter is the following. There was a request for bids by the Airports Company. That was after the 2017 regulations had been adopted. Then there was a pre-qualification for larger companies requiring 30% black ownership. Secondly, there was an interference with the point scoring. It was indicated that 50 points would be scored for price and 50 points would be scored for BBBEE status. And lastly, there was an objective criterion, and it was stipulated that it was not necessary to award the contract to the highest tenderer if the discrimination imperatives requires otherwise. And in both judgments by Monamela J.A. and by Ponnen J.A., it was indicated, but no more weight could have been attached to previously disadvantaged status than the points indicated in 2B, the 10 or the 20 points. And that was in confirmation of previous authorities which decided the same. So all authorities support the fact that we only deal with a two-stage process and not with a three-stage process where we first have a pre-qualification or a determination of a qualified group of tenderers, whereafter the preference point system is then applied. Justices, we say, I must make haste because my time is running out. We say that the regulations, 2017 regulations, are indeed ultra vires the Procurement Act, because what the minister did was the minister provided a further framework, an additional layer as referred to by the Supreme Court of Appeal. He couldn't have added to the framework because there is simply no interpretation of the Framework Act which allows for a pre-qualification stage. I've dealt with the question of acceptable tenders relied upon by the minister to justify the regulations. We say that cannot be. The wide discretion relied upon by the minister in terms of 5.1, of course it is so. There is a wide discretion. The discretion is to make regulations which are necessary or expedient. That is, which are needed or which may be helpful. But it all must be fit in within the framework or the structure of the Framework Act. And it begs the question to say he's got a wide discretion. He does not have a discretion to add to or to cut from or to enlarge the framework that we find in the Framework Act. We also indicate that in terms of the Procurement Act itself, it cannot be said that pre-qualification as provided for by the minister indeed amount to specific goals or objective criteria in terms of 2.1F, because 2.1F is very clear. Only objective criteria in addition to specific goals mentioned in 2.1D can qualify as objective criteria. So to conclude then, Justices, we say that the grounds relied upon by the minister didn't confer the power on him to have added pre-qualification criteria and compulsory subcontracting. What we find in the minister's affidavits filed on his behalf is that the minister indeed attempts to avoid the real question whether he did have the power by indicating there were very good reasons for the regulations. And there were complaints that the previous regulations did not live up to what they were supposed to live up to. That all may be true, but at the end of the day, the fact is that it was for the legislature to make amendments to the Framework Act itself and not for the minister to overstep and legislate by way of making the regulations. In the task team report itself, it was indicated that the minister did not have the power to provide for pre-qualification criteria. If I may refer nearly to page 242. And this was now the task team of National Treasury. At the top of page 242, which we find in volume 3, the following was stated by the task team. It is suggested that the South African legal framework does not provide for the use of set-asides for this advancement of socio-economic policy objectives leveraging on public procurement. The reasons advanced in most instances rise from constitutional provisions, Section 9 on equality and Section 217 on procurement. And then of importance, since no supplier or business may be prohibited from tendering, since no supplier or business may be prohibited from tendering for state contracts, government opted for a system that allows all that meet the tender requirements to tender, but award points to the most transforming tenderers' suppliers. That's the task team. Then there's a recommendation made as an addition. Pre-qualification of tenderers should be introduced before tenders are evaluated further on points and price. But further on, this recommendation is made fully aware that the PPPFA does not give such power to the minister, but it has already been done through Regulation 9. Now, Regulation 9 provides for local content to be taken into account. But the task team itself realized that it was unlawful for the minister to allow for pre-qualification criteria. And then of importance, their recommendation at page 243, the PPPFA in its entirety needs to be revised to address, amongst other, the following: the ambiguity between PPPFA and its regulations, and so forth. So the recommendation by the task team at the end of the day was that the Procurement Act itself needed to be rectified. But we know that that was not done. Instead, the minister chose to legislate, which he couldn't have done in terms of the principle of legality. And for all those reasons, we submit, Justices, that the SCA was correct in their judgment, and in particular in the order that they made, that the regulations are in conflict with the Framework Act. And as indicated in the heads of argument, either leave to appeal should not be granted because there's not a prospect of success, or otherwise, if leave is granted, then the appeal must be dismissed. Those are the submissions. As far as the minister is concerned, as I've indicated, my colleague, Mr. Merabe, will deal with the submissions made on behalf of the EFF. Thank you, Justices.
Thank you. Mr. Merabe.
As the court pleases, the acting DCJ and justices of the Constitutional Court, may I start by indicating that our submissions in reply are purely confined to the 4 topics of submissions made by the second amicus. And our submissions in reply will be very abridged. This early, may I submit that the respondent does not accept that the second amicus submissions will be useful to this court or differs from those of the other parties. As I understood, the earlier submissions of the second amicus is that the issues were dealt with extensively by the minister. And on that score, the amicus submissions are merely in support and repetitive of the argument of the minister. And we submit that they do not raise any new contentions. We say so by analyzing the submissions that the second amicus made before this court. The first topic of the submission made is in relation to the historical and textual context. And we submit that the historical context of the subject matter of the application for leave to appeal is fully canvassed by the minister in its supporting affidavit. And we have referred this court to the relevant passages in the papers. The Minister refers further to this contextual background in its heads of argument, and apart from what the Minister said, this was also dealt extensively by the Minister in policy, in relation to the topic touching on the policy consideration for the adoption of the 2017 procurement regulations, and we have referred this court to the relevant passages in the heads. The second topic which was raised by the amicus relates to the pre-qualification. It relates to the pre-qualification. And on that score, the respondents submit that this topic was also grasped at by the Minister in paragraphs 13, 73, 74, and 75 in its founding affidavit for leave to appeal, and that it was not necessary for the amicus to make similar submissions. The third topic which was raised by the amicus relates to the framework, and the suggestion is that the framework does allow for the preliminary disqualification. And again, on this score, the respondent referred this court to the relevant passages where the Minister made submissions. So those relevant passages are referred to in our heads of argument. And we submit that it was not necessary for the amicus to rehash the argument of the Minister. The last topic that the amici dealt with is with regard to Regulation 4. To say Regulation 4 is not an additional layer. With regard to that submission, we say before this court that the Minister dealt with this issue, firstly, in its practice note that is in paragraph 7.62. The Minister also dealt with this in its heads of arguments in paragraph 70 to 73.4.2. On that score, justices, the Constitutional Court, we submit that the amicus failed to introduce new contentions that will assist this court to arrive at a proper outcome. On that score,
effectively, Mr. Mirabe, you are second guessing us. You are basically saying you justices of the Constitutional Court don't know what you are doing. You should not have allowed the EFF to come make representations here.
That is not a submission, Justice Matlang. That is not a submission. That is not a submission. As it pleases the court, justices of the Constitutional Court. That was our argument. The respondent persists with his argument as set out in its main heads of arguments. As it pleases the court, justices.
Thank you, Mr. Mirabe. Mr. Oppenheimer.
May it please the court, Acting Deputy Chief Justice and Justice of the Constitutional Court, I intend on addressing two issues. The first is who must determine a preferential procurement policy, and the second is who is entitled to be preferred under such a policy. I'm going to start with the second question first. So Section 271(2)(b) of the Constitution refers to the protection or advancement of persons or categories of persons disadvantaged by unfair discrimination. It must be noted that reference is not made to racial groups. Section 21(d)(1) of the Act states that the specific goals may include contracting with persons or categories of persons historically disadvantaged by unfair discrimination on the basis of race, gender, or disability. Now, again, the Act doesn't refer to particular racial groups. It talks about people that have suffered unfair discrimination on these different bases. Furthermore, in the context of the Act, these specific goals are in relation to the points that can be allocated under a bid. And so it's either for the 10 points or the 20 points. No mention is made of pre-qualification criteria, or as Justice Jafta hinted at earlier, the idea of post-qualification criteria, the idea that an organ of state could hold in mind a particular racial group and then wait for all the bids to come in, only then to disqualify. No power is granted to the organs of state in that regard by the legislation. Now, the 2017 regulations specifically refer to race. So a tenderer having a stipulated minimum BEE score, or that when subcontracting that there is 51% black ownership. Now, if we contrast this with the 2001 regulations, these did not refer to racial groups. Instead, they used the term historically disadvantaged individual. So, for example, a South African citizen who, due to the apartheid policy that had been in place, had no franchise in national elections prior to the introduction of the Constitution in 1983 or the Constitution in 1993, provided that a person who obtains South African citizenship on or after the coming to effect of the interim constitution is deemed not to be an HDI. Now, this squares with the important value of non-racialism, which is in section 1B of the Constitution, which says that the Republic of South Africa is one sovereign democratic state founded upon the values of non-racialism and non-sexism. And you must recall the importance of this rallying cry of non-racialism, and the Freedom Charter is a good document to have a look at to understand that term. And it says that South Africa belongs to all who live in it, black and white. The rights of the people shall be the same regardless of race. All national groups shall have equal rights. All shall be equal before the law. And all laws which discriminate on grounds of race shall be repealed. In 1991, the ANC produced a document entitled Constitutional Principles for a Democratic South Africa, which proclaimed that a non-racial South Africa means a South Africa in which all the artificial barriers and assumptions which kept people apart and maintained domination are removed. In its negative sense, non-racial means the elimination of all color bars. In positive terms, it means the affirmation of equal rights for all. With regards to the preamble, this again is mentioned non-racially. It says, "We, the people of South Africa, recognize the injustices of our past and believe that South Africa belonged to all who live in it, united in our diversity." Now, the Minister has referred to the matter of Van Heerden. I'd like to refer to that matter as well. In that matter, Justice Moseneke held that the long-term goal of our society is a non-racial, non-sexist society in which each person we recognized and treated as a human being of equal worth and dignity. Central to this vision is the recognition that ours is a diverse society comprised of people of different races, different language groups, different religions, and both sexes. This diversity and our equality as citizens within it is something our Constitution celebrates and protects. In assessing whether a measure will in the long term promote equality, we must bear in mind this constitutional vision. In particular, a measure should not constitute an abuse of power or impose such substantial and undue harm on those excluded from its benefits that our long-term constitutional goal be threatened. And this is at paragraph 44 of the judgment. Justice Sachs, at paragraph 137, says that without major transformation, we cannot heal the divisions of the past and establish a society based on democratic values, social justice, and fundamental human rights. At the same time, it is important to ensure that the process of achieving equality is conducted in such a way that the baby of non-racialism is not thrown out with the bathwater of remedial action. And in the matter of Pretoria City Council versus Walker, Justice Sachs held that no members of a racial group should be made to feel that they do not deserve equal concern, respect, and consideration, and that the law is likely to be used against them more harshly than others belonging to other race groups. In the Barnard case, Justices Cameron, Froneman, and Majid held that to achieve the magnificent breadth of the Constitution's promise of full equality and freedom from disadvantage, we must foresee a time when we can look beyond race. And Justice van der Westhuizen held that affirmative measures and their implementation are not immune from scrutiny, as is clear from the main judgment. The Constitution states that the measures must be designed to protect or advance persons or categories of persons disadvantaged by unfair discrimination. Schemes and conduct based on race, which arbitrarily benefit some and violate the rights of others, can never qualify as a legitimate measure under Section 9(2). Now, these founding values of non-racialism must be used to interpret the rest of the Constitution. And if we apply these norms to the particular facts of this case, we can see that the pre-qualification criteria set out in Section 4 of the regulations exceed the powers granted to the Minister by Section 5 of the Act. The criteria refer almost exclusively to the racial ownership of the companies that are entitled to submit tenders. Now, the Constitution does not refer to racial groups, but instead rather to those disadvantaged by unfair discrimination. While it is the case that many people who are classified as black were disadvantaged by unfair discrimination, this is not necessarily the case for all people classified as black. The Act does not seek to advance members of particular racial groups. Instead, it gives preference to those who have suffered historical unfair discrimination on the grounds of race, sex, and disability. Black people are not interchangeable with each other. Justice requires compensating those particular people who were historically disadvantaged on the grounds of their race. It is unjust to compensate those who are not historically disadvantaged on the grounds of race, but happen to look like people who were. A black person who is denied the right to vote and the right to live and work in an area of their choosing because of their race is not the same as someone who was born after the fall of apartheid, participates in democratic elections, receives a world-class education at a private school and lives in an opulent suburb and happens to be black. The 2001 regulations demonstrate that it is possible to target those who are historically subject to unfair discrimination on the grounds of race without referring to particular racial groups. The 2017 regulations restrict the power of organs of state to give preference to those actually targeted by the Act. Instead of assisting those who have been disadvantaged by undiscrimination, the pre-qualification criteria in the regulations target companies that tender for contracts which are 51% black owned. This focus on racial ownership is a blunt instrument that serves to advance those who are already in a privileged position since they own companies. No mention is made.
Mr. Oppenheimer, your protection time has expired.
Thank you, Acting Deputy Chief Justice. No mention is made of those communities who are meant to be assisted by the projects which have been put out for tender. The narrow focus exclusively on the race of the owners flies in the face of the value of non-racialism as entrenched in the Constitution. Now, with regard to the distortion that happens in the marketplace, Section 271 requires that all government procurement must be fair, equitable, transparent, competitive, and cost-effective. Now, once a pre-requirement is put in place, what this does is that it narrows the pool of people that are able to participate in a tender. So the way that it works in terms of adding points is that, first of all, the person who comes in with the lowest price determines how points will be allocated going forward. So the person with the best price gets the full amount of points on price, either 80 or 90, and then the others get points on a pro rata basis depending on what price they put in. Now, if certain people are removed from the get-go, what happens is that it might be that points would have been determined by someone, let's say, who didn't have any BE points, but because they're not able to participate, points are then determined on price by someone who is allowed to compete. So this necessarily means that organs of state are going to be paying more for goods and services which are aimed at redressing the wrongs of the past and assisting poor and vulnerable communities. So if we think about a marathon, and we want the idea that everyone is free to participate in this marathon equally, we might think that in order to redress the wrongs of the past, that those that have particularly suffered wrongs are given some kind of preference in the marathon. In other words, they might get more time to complete or start further in the race. But to say that some people cannot participate in the marathon at all.
Mr. Oppenheimer, so to you, how exactly could protection and advancement envisage in subsection 2 play out? How exactly would it? Because Mr. Manager makes the point that established companies, for which I would say read white, will almost invariably undercut companies or smaller companies, for which I would say read previously disadvantaged and in a large measure I would say read black. They would undercut them when it comes to price, which means that some of them could even, and that's based on the economies of scale, because they are large, they may attract discounts, huge discounts. And therefore they are in a position to as I say, to undercut the smaller players in the field. Now, they could even go so far as to just not care about what falls under D, for example, paragraph D. If I get this 90%, or if I get this 80%, I'm home and dry. No matter what the others may do within the 10%, there is no way they will catch up with me, having gotten the 90 or the 80. The effect of which will be things will stay the same. Sometimes, you know, these things get illustrated by anecdotes. As counsel, I was actually involved in 3 matters that fit exactly the point made by Mr. Maineche. That matter, a company that was on the opposite side, an established company, had tendered in the 3 contracts I'm referring to. And they put in an application, and they said, when those bids were opened, our competitors were these sort of companies, and their prices were these. Therefore, on point scoring and based mainly on our price, there's just no way that they could have given us, they could have beaten us. And therefore, based on paragraph, is it paragraph F? And therefore, based on paragraph F, these 3 contracts ought to have been given to us. And they say that even before a Rule 53 record has been submitted. And I was on the opposite side. We had to settle those matters. But the short point I'm making is that business will stay the same. It will be business as usual, I want to say. And so it seems to me that that is what your argument is pushing for. How exactly do we achieve the protection? How exactly do we achieve the advancement if, based on your argument, things must basically stay the same?
Justice, let me address that in 2 ways. The first of all is to point out that neither the Constitution nor the legislation speak of set-asides. In other words, the idea that you can exclude people from participating in the process. In fact, if we look at all the cases that I've referred to on equality, the idea is that we don't exclude people on the grounds of their race, that we allow them to participate. But we want to have redress as well. And that redress is not done on the grounds of membership in a particular racial group. The question is, have you actually suffered an unfair disadvantage on the grounds of your race or of sex or disability? And that's not coextensive. And as is used, if we look at the section, the 2001 regulations, we can see that there's a distinction drawn between people that were denied a vote under apartheid and those that weren't, even though they might be members of the same racial group. The second is to say that it's not the case that you're just going to have the status quo. You're affording a 20-point advantage to people that are in the preferred group. That strikes me as a significant advantage. And to the extent that it cannot be surmounted, well, then I would suggest that those companies improve their price. Ultimately, we must bear in mind that there is a cost.
Easier said than done. Easier said than done to just say improve your price, because in the end, you'll end up getting nothing out of the contract. That's easier said than done, Mr. Oppenheimer.
Well, Justice, I would submit that there is a cost in disregarding that structure. So, for example, we have to bear in mind that cost effectiveness is one of the requirements mandated by the Constitution, and this is being paid for by the taxpayer. In other words, there is a limit on how much of a role redressing the wrongs of the past can be played and how much has to do with service delivery going forward. And we must also bear in mind who are the beneficiaries of these services procured by the state. Often they are the poor and the vulnerable. And to my mind, in other words, if what you care about is redressing the wrongs of the past, it is those people who deserve the best possible service at the best possible price. Now, Justice, you had earlier stated that you could say that big business is white and that small businesses are black. I would submit the following, which is that you can have a business which is 50% white owned and 50% black owned. Because it is not 51% black owned, it can be excluded on the grounds of these pre-qualification criteria. And it can also be the case that every single employee of that business is black. Versus, let's say, a company where you have 51% black ownership and every single employee is white. So there's a distortion that goes on here. And again, as I stated earlier, if we take non-racialism seriously, it's not about the racial group that you're a part of. The determination must be more sophisticated than that. It must ask about...
The problem is, I understood you to be saying the best is having what we have. If you get into the detail of how, for example, the pre-qualification is done, that is something else altogether. If you say, but not like this, but to outright say pre-qualification is not at all envisaged in the Constitution, that's something else altogether. But the detail about the 50%, 51, and so on, that goes into how exactly do you do it? As I say, that's something else altogether. But at a conceptual level, I am not altogether convinced that the Constitution outlaws pre-qualification. I am not.
Well, Justice, I'd submit that it definitely doesn't cater for it explicitly. And it doesn't say that racial groups can be excluded from participation. It talks about preference. And there's a difference between a preference and a set-aside.
Category, not just preference. It talks about categories of preference. So you must interpret categories as well.
Yes, Justice. So the language...
It may be categories of disabled people, categories by gender, categories by race, or categories that include all of these and possibly more. Categories. So you must give meaning to that as well, not just preference.
Well, Justice, I'd submit that 2172A talks about categories of preference in the allocation of contracts. And then B specifically says the protection or advancement of persons or categories of persons disadvantaged by unfair discrimination. Neither of these refer to set-asides or pre-qualification criteria. There's a difference between preferring someone in the sense that they can do better in the marathon than saying that only those people can compete in the marathon. And pre-qualification criteria assert themselves to the level of a set-aside, and that certainly isn't mentioned at all in the Act.
My problem is I read, using your analogy of a marathon, I read your argument to basically say it's fair for somebody to say, let us run from Pietermaritzburg to Durban, but I'm going to start in Pinetown and you start in Pietermaritzburg.
Well, my knowledge of the comrades is not as good as Justice Malanga's, but my point is that, in other words, in awarding a preference, one can state that the following categories of people, which must be not racial categories, but people who've historically been disadvantaged on the grounds of race, those people can start ahead in the marathon. In other words, they get a 20-point or a 10-point advantage. So you might say, instead of having to do 80 kilometers in this marathon, you can do 65 kilometers. That you're allowed to do. But you can't say the following people don't get to compete against you.
In my analogy, the people that I was placing in Pinetown, which is very close to Durban, are your established white companies. That's who I was placing ahead, which is basically, a business being as is, business as usual.
Yes, Justice Malanga, if that is the quibble, then the quibble is with the way the legislation is drafted, which is that the way that points are allocated is either 10 or 20. It might be that other criteria could have been crafted by the legislature, but those are the criteria that have been crafted. It may be that the legislature had the power to have crafted different legislation, but this is the legislation that is there, and it doesn't make mention of...
I was just engaging you at the level that I thought you seemed to touch on what even the Constitution itself envisages or does not envisage, because you started off by setting out what you considered to be the applicable constitutional principles. That's the level at which I'm engaging you. not at the level of what the Act itself now says or provides for, if you see what I mean.
Yes, well then, Justice, at the level of the Constitution, I would submit the same, that the Constitution certainly doesn't envisage the idea that some people are excluded from participation in society on the grounds of their race. In other words, if we acknowledge that race and racism have been at the source of South Africa's many problems, we must accept that they cannot form part of our solutions. That the way through a non-racial society is to redress the wrongs of the past, but it is to do it non-racially. And it is not through race-based set-asides.
By the way, it's not as if the policy, or does it, or the regulations, it's not as if they are saying established white companies can never, ever, ever participate in procurement, do they?
Well, Justice, I'd submit that if the pre-qualification criteria are utilized, then it is quite strict as to who is entitled to compete. And so, for example, if black ownership is used as that requirement of 51%, or having a certain BEE status, then it may very well mean that they are excluded entirely from the participation. And that's very different from allocating a preference. Justice, I'd then like to turn to the first issue which I addressed, which is this question of who must determine the preferential policy itself. Now, the Act states quite explicitly that it is the organ of state that must determine its preferential policy. And I would submit that Section 2 is a special requirement, and that the power given to the Minister in Section 5 is a general requirement, and the special must trump the general. Now, the Minister then cannot exceed the powers which have been granted to it by the Act. And really what we have is there's a reason why the power has been granted to specific organs of state, which is to determine their policies, which is that they are better placed than the Minister to determine their own procurement policies because they're embedded in local communities and are more sensitive to the needs of those communities. A rural municipality or a provincial department of health is more likely to know the consequences of a procurement policy on those participating in a tender process and those that will reap the effects of the goods and services produced by the successful tenderer. The Constitution vesting this authority in specific organs of state rather than a single minister was therefore for a good reason. And if we bear in mind the sort of general reason why the separation of powers is important, the idea is that a concentration of power will most likely lead to self-interested action and an abuse of power for personal gain. Historical experience suggests that benign dictators who rule wisely, judge fairly, and generally advance everyone's welfare are very hard to find if such people ever existed. The underlying idea beneath any separation of powers doctrine is thus the skeptical assessment that good governance is more likely when political power is distributed between different institutions and persons. It means that specific functions, duties, and responsibilities are allocated to distinctive institutions with defined areas of competence and jurisdiction. So what we have here really is that the Minister is trying to usurp the powers of the particular organs of state. Now, what's clear is that because the organs of state have the power to determine, what the Minister has done, the legislation basically says the following, which is that organs of state, by analogy, are free to eat whatever food they would like. And the Minister then says, as long as it is from this particular restaurant. So there's a constraining that happens. In other words, the Minister says, well, the organs of state can choose whether they want to apply pre-qualification criteria or not. And therefore, the discretion remains with them. But they can't determine the contents of that pre-qualification criteria. That has been determined by the Minister. There is a closed list, which the Minister has said it must be something off this list or not at all. Now, if the legislation is taken seriously, it means that the organ of state must have the power to determine, in terms of the Act, what those preferences will be and what the policy will be and what the specific goals are. And instead, what you have is the Minister saying, well, you can have any goal you like as long as it's this one. And that really is to usurp the power that the organs of state have in terms of legislation. So I would submit that what the minister has done is really to create legislation, as opposed to amplifying the meaning of what exists in the Act. We find nowhere in this legislation the power to designate specific racial groups or to have pre-qualification criteria at all. And so regardless of what one feels about the morality of what the minister has done, one might think that this was a laudable aim. It certainly is beyond the minister's powers, and on that basis must be viewed as ultra vires. I therefore have no further submissions.
Thank you, Mr. Oppenheimer. Mr. Van Zyl.
May it please you, Acting Deputy Chief Justice and other justices of the Constitutional Court. I've referred in my heads of argument to an introduction that is also an introduction in the South African Informal Traders Forum and others versus the city respondents. And I think it's apt in the current case. And I repeat the excerpt of the Honorable President Nelson Mandela. Even the most benevolent of governments are made up of people with all the propensities for human feelings. The rule of law, as we understand it, consists in the set of conventions and arrangements that ensure that it is not left to the whims of an individual ruler to decide on what is good for the populace. The administrative conduct of government and authorities are subject to the scrutiny of independent organs. This is an essential element of good governance that we have sought to have built into over the new constitutional order. Now, against that backdrop, Justices, we've accepted that the Constitution is the highest rule of law. The public authority and public power has to be executed in terms of that highest authority. Even though transformation is a sought-after goal, that also has to happen within the contents and within the four squares of our Constitution. What we say and why we say this is applicable is the benevolence most assuredly was for transformation. But because it's not done within the contents of our Constitution and within the contents of the rule of law, it has caused collateral damages. It has caused collateral damages for the applicant. It has caused collateral damages for the applicant's employees, the second applicant's members, the employees of the members. And I'll take the justices to that at a later stage. It has also affected the QMEs and EMEs for who this regulation seems to have been promulgated for. So if I can just take one step back, it's important to note that the second respondent launched an application for review, setting aside the regulations because it's invalid or ultra vires. This review has been appealed to the SCA. The SCA made an order declaring that the preferential procurement regulations 2017 are inconsistent with Preferential Procurement Policy Framework Act 5 of 2000 and are invalid. The declaration of invalidity, obviously, in terms of paragraph B, was suspended for a period of 12 months. It serves to mention, it's very important, that the argument that was made there is that whether the first respondent exceeded their powers in the promulgation of the regulations, and was this exceeding of his powers reviewable? And that's important justices of the court, because that's what we say. We say, I apologize, we say that he has exceeded his powers and he has made legislation. In fact, the promulgation of these regulations have circumvented to a large extent the framework that was created in terms of section 2173. So with that as the background, the applicant asks to join the proceedings as a party. That's envisaged in Pres 2 and 3 of the notice of motion. That's the first point of reference. That's the first point that I will be discussing. The second portion of the applicant's case is to apply for interdictory relief. That's envisaged in Pres 2, 4, 5, and 6 before the Honourable Court. Now, the last mentioned Pres were heavily disputed, and we've conceded that in the replying affidavit, if the wording of Pres 4, 5, and 6, 2, 4, 5, and 6 do not accord with what is required in the circumstances, we concede that the court has the jurisdiction and obviously the wide discretion to affect what we need as relief. So what the applicants are in fact asking is that the implementation of these regulations that were an exceeding of the first respondents, the minister's powers, that be repaired, that the implementation be stopped, and that the harm be prevented from here on forward. That's what's needed by the applicants, and that's what prayed for. The applicants responsible for 58,000 people, employees that work for them. They are a BEE level 1 certified company. They are 100% South African. The application is brought by the people on the ground, and I say that for very specific reasons. The second applicant has about 103 members, also 110,000 employees that are connected with the second applicant. The second applicant is connected with the first applicant. But because of the process, the implementation of the regulation, the first applicant is completely excluded from being able to compete with other persons. The problems with that is that also excludes the second applicant, and it causes harm and prejudice to all the employees, because those employees are allocated to certain contracts that are served by the first applicant and the second applicant. That's why we say that it also affects the employees. The applicants then, in so doing, provide specific facts that are unique to them in relation to the implementation of the regulations and how it affects people, and how it affects the applicant and the second applicant and the employees and the public interest. The applicants opted for a joinder because we need the evidence to be placed before court rather than just the legal theory and the legal argument. The first applicant adhered to the requirements called for in terms of broad-based Black Economic Empowerment Act 53 of 2003 and qualified as a BEE level 1 business. The regulations, obviously, and that's the whole crux before this court, has created the pre-qualification without a proper framework to adhere to. In fact, it circumvents the legislation and does not advance the requirements of 217, and I will attach an argument to the debate that's been before court till now. And we say, therefore, that it is ultra vires. We also say, obviously, that the implementation of these rules affect state assets. The applicants are at the moment, or the tenders that they have held till to this point, is for the guarding and taking care of state assets and state infrastructure, as, for example, a Medupi power station. It refers to train stations, it refers to schools, even courts are tenders that the applicants currently hold. And the problem is these QSEs and the EMEs, and we make the points and the allegations in the papers, are normally ill-equipped to meet some of these standards. And what happens if those people are, whether they are functional or not, but they are the best entity to be appointed? What happens when they are appointed? They are appointed in a position that they should not be in, and they cannot properly deliver the service. Disputes arise. It disputes between the EMEs, the QMEs, and the state. There's litigation as a result thereof. Other contracting parties are approached, and that's the result.
Through you at ADCJ, I'm not sure whether protection time
Still protected.
it is still protected.
Yes.
Oh, thank you. Sorry, I'll wait for it.
Please, Justice.
Hello.
If I may make, there's just 3 or so more points, and then I'm getting to the core legislation, and then we can assuredly get to the debate before court. The applicants are losing millions of rands due to the application of the regulations, but we have to be careful. The applicants are not saying that this is a purely commercial, a purely economical exercise. They're losing the benefit of the tenders. They're losing the right to tender. That's the problem. They're not competing. And if we look at the 217 of the Constitution, it has to be a system that is fair, equitable, competitive, and transparent. So the competitiveness is taken out. It's cost effective. It has to be cost effective. That's also something that has to be considered. We say that the implementation obviously affects all the applicants' tenders. We say that we held these tenders in the founding affidavit. It was 150 tenders, 130 tenders, and in the replying affidavit, another 50 tenders were affected. So there's effectively 188 tenders that were affected by the implementation of these rules. And it seems that this implementation is not as provided by the first respondent, a discretion that was provided. It's not a discretion of the organs of state. The organs of state, ESCOM specifically, on 2 occasions came back to us that they are applying it as the application of the law. And they are waiting for instructions from Treasury to decide what to do with the regulations. So that doesn't sound like it's an implementation of a discretion. It's an application of the law according to them.
Mr. Fadel, your protection time has expired.
May it please you, Malene, acting judge, deputy judge.
Thank you. Mr. Van Zyl, I just want to raise 2 questions at this stage. The first one relates to the interest of the applicants, whether they have a legal interest or is it a financial interest. And then the second question relates to the implementation. You keep on saying that you want this, the implementation of the regulations to be stopped. Do you accept that the party that is actually implementing the regulation is not the minister, but the state organs, and they are not before us? How are we going to go about with that process of stopping the state organs to stop implementing these regulations when they have not been joined to be respondents or parties in these proceedings today?
My lady, the first point regarding the right or our interest. we say our interest is not only commercial. The interest that we have is also, there's like we said, 58,000 employees, or 58,000 employees, and the second respondent, second applicant, 110,000 employees. These employees are attached to certain contracts, to certain tenders. Now, because we are being precluded from competing, and that's a right in itself. We were entitled in terms of the PPPFA to apply for these tenders. That has now been taken away. Now we're no longer allowed to do it. And the effect, obviously, is those employees, says their employment is at risk. And that in itself is not only commercial. My lady, then, I apologize, Justice. If I can refer to Annexure RA1 and FD 14.3 of the papers. FD 14.3. FD 14.3, and if I may just read that, it says the following in the last two paragraphs. National Treasury have advised that they are in the process of studying the judgment and cannot provide guidance in line with the judgment currently. They have emphasized that the declaration of invalidity arising from this judgment has been suspended for 12 months, and that consequently procurement processes should continue as per usual until further notice. We will communicate any feedback from National Treasury as and when such feedback is received. So if one reads that letter, it doesn't sound like it's a discretion from the organ of state, but as an instruction from Treasury. And then if one looks at RA1, we've bundled and indexed the papers on page 521, the last two paragraphs says the following, and this is a letter from Group Chief Executive Andre de Ruyter. As an organ of state, Eskom remains bound to the state of the law, as it is at the time of issuing of the tender and evaluation and awarding thereof. The judgment states that the declaration of invalidity is suspended until November 2021, and thus will be irrespective of the progress of the minister's appeal against the order. In the premise, I advise that in this regard and in respect of the issues forming the subject matter of this correspondence, Eskom will continue the management of its tenders in accordance with the Preferential Procurement Act and the so-called 2007 regulations, since it presents the state of the law. And again, Justice, it seems that it's an instruction rather than a discretion. And that's how it is being applied.
But how is it an instruction? I don't understand. I really don't. My understanding of the principle of objective invalidity, where a code of law says law or a decision is invalid because it does not comply with the requirements of the law, but the court itself suspends the declaration of invalidity. It is the court, not anybody, that says the invalid law or decision must continue to operate. So how does it become an instruction?
I would rather say that specifically in relation to the first letter, that they were awaiting instructions from the Treasury, and that they would advise upon receiving such instructions. And that's specifically stated in that letter.
No, it may well be so, but if they were wrong, the law is for as long as the declaration of invalidity is suspended, the regulations continue to operate. That is the law. Whether
I accept that.
So I think we should stick to what the law says and see how your client's case can be advanced within that context. Forget about people who are bringing in wrong views and because it will waste our time. We have to determine whether or not, as I understand it, in the meantime, whilst the declaration of invalidity is suspended, the interests of your clients are protected. And the issue being how do we get to protect them? And that is what you were debating with Justice Mhlantla and other justices. How do we get to protect the interest of your clients within that period of suspension, if it is competent in law to do so? And I'm interested in hearing you on that one.
Justice, if I may just make the following statement. What we say is that the first respondent has exceeded his powers in promulgating the regulations. I would submit that in the circumstances where he has exceeded his powers, he has transgressed his powers into the authority of Parliament, that this court can and should be able to make, with the greatest of respect, an order preventing the implementation of the regulation as it is, and to return to the status before the implementation of the regulations.
Can we do so when the order that suspended the declaration of invalidity was made by the SCA?
Justice, the problem is the SCA has made that order, and that is a question before this court today, the invalidity, and that's the problem that the applicants have. They can't really approach.
What you are saying is that we should, in the meantime, order in the interim that what the SCA has suspended and said it won't happen, it must happen. And as I understand it, the one issue was, in terms of Section 18 of the Superior Courts Act, if you want an interim implementation, you have to go back to the court that made the original order. That's what I understood. So I'm interested in hearing you making submissions on those points.
Yes. If the problem that we have specifically with Section 18, Section 18 of the Superior Court Act, if we ask for the Supreme Court of Appeal to suspend the suspension, in other words, implementing their order, there is still a suspension until November. So we're sitting with exactly the same problem. The harm that we speak of is still going to take place until the 21st of November. So whether we approach the Supreme Court of Appeal to suspend the suspension or to enforce the order makes provision for a suspension until 21 November.
No, Mr.
That would not assist us with the harm.
Mr. Van Zyl, if the SCA issued its order in November last year, if you had gone to the SCA in terms of Section 18 of the Superior Courts Act and asked for a suspension of that suspension order, as you put it,
yes,
SCA may have well granted you that order. I don't understand your argument that if you go there now, if you had gone there, you would not have received the order that you seek, the SCA.
So So just as the order makes provision for invalidity of the order and that be suspended till November. If we apply to court to enforce the order pending, then that suspension would still be enforced until 21 November, as I understand it. In any event, we only felt the effects of the proclamation and the implementation of the regulations in January, February, and March, and that was where we decided, where they had to decide to do something, and it was considerable effects. It wasn't one or two tenders. Obviously, initially we thought that it would be a predetermination on a discretion, but it wasn't implemented. It was implemented right through the MAG. It was implemented on all our tenders, and that's to date 188 tenders. So that was not the case when the decision was made in November. That was the case in the beginning of January, February, and March.
Mr. Fanzel, the question is whether Section 18 permits us to do what you're asking us to do. That is the question of competence. Does it require you to go to the court that made the order, or does it permit the court before whom the appeal is pending to make the change?
I understand your Justice's question. The concern is if we approach, because it's now 3 or 4 months past the date, if we approach the Supreme Court of Appeal now, then we are asking for a suspension or the enforcement of an order that in itself makes provision for suspension until November. And that question, the validity or invalidity of the regulation, is before this court. So we can't really approach the Supreme Court of Appeal because the enforcement would only mean that there's a suspension that's applicable.
What you are asking, ordinarily, isn't it that in terms of the common law and the uniform rules of court, once there is an appeal against a judgment, that judgment is suspended until the appeal is finalized.
Yes.
A judgment on appeal is given. Now, Section 18 comes in to say, there would be circumstances where execution pending appeal should be undertaken. Now, as I understand it, and correct me if I'm wrong, as I understand it, what you are seeking now is what is authorized by Section 18. Execute the order, declaration of invalidity based on lack of power. Execute it now. Don't wait on the basis of the suspension given by the SCA. Now, if that is the position, the question is whether Section 18 grants a court that did not grant the order appealed against the power to authorize execution pending appeal. That is the competence issue or point that I was referring to.
May it please you, Justice. If I may, that's why the application is worded firstly Section 18, and then we say in Prayer 4, in the alternative or in addition. If I may just make that, read that wording for the court. My Lord, that's why in Prayer 5 we say in the alternative to Prayer 4, Prayer 4 refers to Section 18, 1, 2, 3, and 4, together with Press 6 here in further, Press 6 is defined as the mandamus by the first respondent. And in addition thereto, in circumstances where the Supreme Court of Appeals court order is suspended until 21 November, that the first and second respondent be interdicted to apply the preferential regulations 2000 in procurement process pending the final decision by this court. So I would submit any order that suspends the implementation of these, because the implementation is making people suffer and is causing the severe prejudice that it is causing currently.
No, but then you would have two conflicting orders. The one from the LCA says the declaration of invalidity is suspended for a period of 12 months, which says to those who are applying the regulations, you can continue to apply the regulations because the declaration of invalidity is suspended. Now, if we come in to interdict them, we interdict them from applying the law as permitted by the LCA. Now, is that consistent with the rule of law that requires certainty and clarity in what the law says?
Well, my lord, I would say that this court has an overarching discretion, and it can see the harm that it is causing and the effects that it is having on the applicant, the second applicant, and the employees. And in those circumstances, I would submit that the court has the authority and the power to interdict the implementation of these regulations.
And what would be the source of that authority?
My lord, excuse me, Justice, I'm sorry, I know.
Yes, I'm trying to think now. Isn't it that in, was it Outer, where this court said an interdict that stops a public official from exercising public power conferred on them must be granted only in exceptional circumstances? Are we in that terrain here of exceptional circumstances?
That's the argument that the applicants attempt to make in the papers, as well as in the heads of argument, Justice, that there is exceptional circumstances, that we are prohibited and won't get effective relief from any other court but this court. And because there's no alternative and no alternative approach to court, that this court should come to the aid of the applicants with respect. That's why we say the exceptional circumstances is that we cannot approach any other court, and that's why we're before this court. We can't approach the High Court for interdictory relief. We cannot approach the High Court for a review application on these discretions that are exercised, because it's a review application that was considered by the appeal court and is now before this court. We can't approach the Supreme Court of Appeal the circumstances that I've just described, because it would just mean that there's a suspension of the order for a period till November. What we're trying to attempt to stop is the bleeding and the collateral damage that it has affected till now.
Why would the SEA not be in a position to grant you execution pending appeal?
My lord, that question, Justice, I would submit that because that question is before this court, they they will be slow to interfere with something that's pending before this court. It's the proclamation, the validity thereof is pending before this court.
Okay, I see. I thought that we had agreed that insofar as Section 18 is concerned, the competent court would be the SCA. But you said, well, in the alternative of Section 18, we are asking for an interdict.
Yes.
Did I misunderstand you?
Yes, that's exactly what we say. But we say we can only approach this court, and that's the exceptional circumstance that we deal with.
Okay.
Vansayo, can I ask, why is this matter urgent for your clients at this particular juncture? There's been proceedings in the High Court, nothing happened. Proceedings in the SCA, nothing happened. And now you approach this court on a basis of urgency as a court of first and last instance. What is the urgency?
Yes. So what the applicants say in the papers, Justice, is that the effects of the implementation of these regulations only took effect since January, February, and March of this year. I think in November and December, they stopped applying for tenders because they saw that discretion were actually implemented, and as a result, they had to approach legal advice, and they continue to implement. They continue to apply since January, February, and March. And in March, the effects are felt. They see that they've lost 138 tenders, and since then, another 50 was lost.
The judgment of, sorry, just finish.
So the urgency is because the leave to appeal is currently before this court. We had to approach a court before this this honourable court has made the judgment. If we don't get the opportunity to give the court the facts of our case, our chance would have been we would have missed the chance to give the court all the evidence and the information before that's currently before court.
When the High Court gave judgment and dismissed the application of the present respondent on 28 November 2018, you say your clients were not affected because there was an application challenging these regulations that was dismissed. You say your clients were not affected in November 2018.
Well, we only lost tenders since we didn't apply in November and December, but we only lost tenders from January, February, and March, and that's the effect.
So
if
you see,
apply,
your answer means that therefore for commercial reasons only. That is why there's urgency. The urgency is self-created. Because for commercial, purely financial reasons. Is that what you are submitting?
No. If I may add to that, the fact is there's security guards that are employed by the applicants, both first and second applicants, and all the security guards are connected to a specific tender, a specific project. So all of those employees are now excessive. And we're talking about a lot of employees. We're talking about 138 tenders worth of employees. In the papers, we say it's at the stage of the founding affidavit, about 895 employees that can't be allocated to tenders at this stage. So it's not purely economical, it's also the interest of the employees. And then obviously we said there's other collateral damage as for example, the QMEs and the EMEs that may be appointed because they're the only ones competing. So the best person for the tender will be the best entity for the tender will be appointed, not necessarily be the best of all of the contenders, because there's no fair competition because the applicant is excluded for the moment, and that's the problem.
Yeah, must I understand your debate with Justice Jafta to mean that you concede that you cannot proceed with the relief sought in Pre 4 simply because you should have brought that in the SCA?
Well, no, what we say is in the SCA, it would not have assisted us to bring that relief.
No.
What I say is...
Let me just rephrase that question. Justice Jafta dealt with you with the provisions of Section 18. And Section 18 is clear that you must bring that application for the order notwithstanding, and further application for leave you must bring in that particular court. And that is just a codification of the common law as it was. So do you accept that this court cannot consider the relief sought in Pre 4 because simply you should have brought that in the SCA? Do you concede that? Because then you revert to Pre 6 or Pre 5, sorry, the interdict.
Yes. Yes, my lord, Justice, I would simply state that an order effectively stopping or preventing the implementation of the regulation is what is required to prevent the harm, the further harm from taking place. So I accept what Justice is saying, that would not be possible in terms of Pre 4, but then that Pre 5 should then be sufficient.
Yeah,
what the applicant is, the applicants are...
No, please finish. You can finish, Mr. Van Zyl.
The applicant seeks any order that would obviously suspend the implementation of the orders. So, and we say that the court has the discretion and the authority to make such an order. And whether it is by the wording used in the notice of motion or not, we concede that.
Yeah, thank you.
As I've indicated earlier, I would like to just add to the debate in relation to the state must determine its preferential procurement policy. That's Section 2 of the PPPFA, and implement it within the following framework. And then the debate was about whether the organ of state can determine the objectives as described in Section 2172, and then implement the people that they have chosen in terms of the remainder of section, as I understand it, Section 21A, B, D, and F. I would just make one argument in this circumstance. 217 specifically states, when an organ of state in the national, provincial, local sphere of government or any other institution identified in national legislative contracts for goods or service, it must do so in accordance with a system which is fair, equitable, transparent, competitive, and cost effective. So the last two requirements of competitiveness and cost effectiveness
Mr. Van Zyl, we seem to have lost you.
May it please you, Justices.
We lost you temporarily.
I apologize. If I may repeat that, Section 217 of the Constitution says the goods have to be acquired in a system which is fair, equitable, transparent, competitive, and cost effective. Now, we say the regulations that were promulgated, and it's purely as a debate, and to add to the debate between my colleagues and Justice Jafta and Madlanga, the pre-qualification, predetermination of a group of persons without a framework, because 2173 also says that the framework has to be a framework has to be provided within which these discretions are exercised. Now, if you pre-qualify and predetermine that only QMEs and EMEs may apply for the tenders, that is not competitive, and it's most certainly not cost effective, because all of a sudden the group of people that apply for the tender are a smaller group of people. And the people that are better equipped, that have the infrastructure and that can come with better prices and functionality, they are excluded from the process. So I would submit on that.
But does section 2171 say competitiveness only means when there's going to be a big group?
No, it does, most certainly does not.
So why do we link competitiveness to a small to a big group?
Justice, I would necessarily say that if you compete with a smaller group, it takes away competitiveness. When there's a larger group and people that are functionally better to apply for these tenders, then there's a competitiveness that would actually say that would actually meet this requirement.
But the Constitution doesn't say so. We had over and over again things like, because the Constitution doesn't say you must give an exclusion in advance. It doesn't say you must give an advantage or preference to Black people and so on. We have, but I'm asking now, because the language of the Constitution doesn't say that. Once there has been a limitation to a group of previously disadvantaged persons, there cannot be competitiveness within that group. It doesn't say so. So you can still apply section 2171 within that group, because 2 says what 1 requires does not prevent you from protecting and advancing those who were previously disadvantaged. So we know that we have to read 2171 and 2172 together and try to create harmony between the 2 sections. The second one intends protection and advancement of those who were previously disadvantaged, and it says you can have categories of preference of those people. So I don't understand the argument that says, oh, no, because now you could have had a bigger group of competitiveness. It's no longer competitiveness if it is within a smaller group, and therefore section 2171 is not complied with. I have difficulty with that. But
Justice, because of the applicants being excluded, they aren't able to compete at all. So they're not part of the competition.
No, but Mr. Fansel, the problem is, as I understand, the regulations don't say those who are advantaged can never submit tenders. The regulations say if and when an organized state is minded to protect or advance the previously advantaged groups, it may preclude or exclude beforehand the other groups. So it doesn't mean that you can never submit tenders if you are in the other groups, or that the only people who would be able to tender for goods and services in the state are those who were previously disadvantaged. If it said so, then it would be contrary to section 217 when you read it together, 2171 and 2172. But because it gives people a discretion to say, in this particular tender, we're going to have an exclusion to those who are previously disadvantaged in order to protect them. Because you had the debate between Justice Madlanga and Mr. Oppenheimer about the undercutting of trying to protect and advance previously disadvantaged people within the restricted 20 points that are allocated to them. So I don't find, if for example, you were to say, the facts are that in respect of all tenders that were held by your clients, the state says you are excluded in all of them, then that'd be a different cause of action altogether. And the problem would not be with the regulations. The problem would be with the state when it implements the regulation.
I've got 3 comments on that, Justice. The first thing is the regulation allows for that discretion at the moment. And that's what the Court Quo warns of and forewarns about, that it allows for abuse. And that's what we are concerned with, and that's what we're attacking.
No, Mr. Fonseca, we can't strike down legislation, subordinate or otherwise, on the basis that some people are going to abuse it. When they abuse it, they are not applying it properly. So that can be a basis of pulling the regulations down because they are abused. Where there's abuse, the focus must be on the abuse, not on the regulation.
Justice, in those circumstances, I must say the following. We have to just be mindful of the fact that the applicant, the first applicant, is a BE level 1. And because this is not a specific group, he is disqualified because he's not a QME or EME. But in those circumstances, in the determination phase that Justice Jafta has spoken about earlier, that determination has also have to take place within a framework. If the determination is a sole discretion, that's the abuse that the Court Quo has warned about. So the determination that Justice Jafta has spoken about, that is without any framework. There's no framework within which the discretion has to be exercised. And we say that the regulation, in other words, has circumvented the Act, the PPPFA Act and the BEE Act.
Okay, thank you.
In relation to the, I'm going to step off for the moment from the legal position and discuss our first application is for joinder to the proceedings. We say that we have uniquely specific evidence that are factual evidence that's uniquely within our knowledge, and that we offer that to this honorable court. What we tendered to the court is that we've previously held certain tenders with the SABC, with Eskom, with Transnet, and we've lost these tenders in the sense that we are no longer allowed to apply for these tenders. We are precluded. We have invested certain infrastructure in and around these spaces, and therefore functionality-wise, the applicants are better suited to apply for these tenders. But because of the pre-qualification, we are now excluded to compete. We have lost that right. The problem with the fact that QSEs and EMEs, and I've mentioned this before, the QSEs and EMEs are ill-equipped to be able, are ill-equipped and does not have the same infrastructure, and the problem with us being determined as disqualified is that the best person or entity for the job will then obtain the tender, and because they are ill-equipped and they don't have the proper infrastructure, that would automatically lead to the fact that at some point there's going to be disputes. They won't be able to deliver the service that they should deliver, and at the end of the day, it's going to be less cost effective because another contractor would have to be approached. In any event, because of the fact that the first and second applicants have held these tenders before and are better equipped to apply for the tenders, they would most probably be also a better priced option, and therefore the regulation foresee that there's a cost implication or a penalty because of the regulation. I've mentioned the second applicant consists of the 103 members and the employees that are affected by this.
Mr. Fansale, on the latter argument that you are putting forward, are you saying this court should entrench what seems to be the monopoly that the applicants have been enjoying? As you say, the infrastructure is there already, and any newcomer will not meet the standard that the applicants have set up.
No, what the applicants are saying is that they would at least have the opportunity to compete and to apply for these tenders. Not that they automatically have to get the tenders, but that they get the fair chance to be competitive.
But this is one of the aspects that the regulations tried to deal with or to address. Are we in agreement?
Well, my lord, our argument is because of the regulation and the fact that the first respondent has exceeded his powers. The effect of it is that there's no competitiveness. That's what the applicants are saying.
Okay, thank you.
May it please you, Justice. I've dealt with the fact that we deliver evidence that applies the regulations as an instruction rather than a discretion. The fact that we have complied with the BEE level 1 certificate and previously applied in terms of the PPPFA and its point system and the ability or its competitors, we don't reach the point system. We don't reach the fact that we are functionally considered and the fact that our price is cheaper than the next person. So we don't get to the point where there's an accounting. Then the reason for the direct access I have dealt with previously. We ask for the court to sit as first instance for the simple reason that we believe that this is the only court that can come to our assistance. And on that score, I refer to Besarglik versus Minister of Trade and Industry. That's the high watermark for the applicant, that we can't apply for relief at the High Court, because the High Court has considered the review has served before the Court of Crow as in an appeal, and that same question is before this Honourable Court. That's also the reason why we say we cannot approach the Supreme Court of Appeal, because the Supreme Court of Appeal's order specifically makes provision for the suspension of the order until 21 November. So if we approach the Supreme Court of Appeal in terms of Section 18, the order will, in the effect, would only be that there's a suspension until the 21st of November 2021. What the applicants say is that the attack is not aimed at the enterprises and their discretion in itself. It's on the promulgation of the regulation. That is the root and the bigger picture. It's the root of the discretion that was given, and we offer evidence that shows that there is now an abuse. We have been excluded from the tender process completely. We have, as a result, lost the 138 tenders that we referred to. We say that the relief sought does not anticipate the court's order. It would simply have the effect that the implementation is postponed. So we say there's two scenarios here. Firstly, if the court finds that the proclamation and the regulations are valid and the harm is prevented with the relief that we seek, all that happens is the implementation of the regulations are postponed until the time that the court has found the regulations to be valid. The last scenario is in the event that the court finds it to be invalid without the relief prayed for, the applicant suffer the harm unabated. If the relief is granted, it is submitted that the harm and the prejudice have been duly prevented. We deal with the effects that the implementation of the regulations had in practice with the applicant, its employees, and what it will have in the future. We say that a broader public interest exists, and I've dealt with the QMEs and EMEs that are appointed invalidly. There's another public interest that does exist. If the court finds that these regulations are indeed invalid, and we've gone too long and too far down this road, the QMEs and EMEs that have now been invalidly appointed, the court might find that there's too much time that has passed, or it would be too much hardship to take them out of these positions. So they've acquired it invalidly, but because of the hardships, we cannot terminate the position that they hold currently. So we say that the general rule of law also suffers prejudice. We say that the review applications of about 180 tenders, although it may be foreseen in the future, this is aimed at the promulgation of the regulation itself. It's not aimed at the discretions. What makes this problematic in any event is whether in the current scenario where the Court of Crow's decision has suspended the declaration, and where this court is now settled with that question, whether that makes that discretion reviewable in any circumstance. we've dealt to a certain extent with the urgency of the matter. We would submit, in addition to what has already been said, the urgency also as to relate to the harm that is being suffered and the prejudice that is being suffered. And what we say is this is a continued process. If the court does not make an application, the harm will continue to be suffered. So the prima facie right, we say that in terms of section 217, when contracting for goods and services, and the organs of state have to do it in a system which is fair, equitable, transparent, competitive, and cost effective. What the applicant's saying is that it's not done in terms of such a system. We are now precluded from applying for these tenders, and we've lost the right to compete. And as a result, we say that that's the prima facie right that has been affected. We say there's no alternative remedy because this is the only court that we can approach, and I've made that argument. There's a well-grounded apprehension of the irreparable harm. Obviously, there is this commercial side. We've lost 189 tenders, and I say lost because we've lost the opportunity to apply for it, and we held these tenders previously. We say that there's approximately, there's damages suffered and there's a calculation made on the previous value of these tenders. This also obviously translates to the employees that are allocated specifically, and that refers to who's going to face the brunt of these transgressions, who's going to face the brunt of the effects of the implementation. It's not going to necessarily be the applicant. There's a public interest here. The QMEs may face it, the EMEs may face it, the employees may face it, the people on whose behalf these tenders were, on whose behalf the organs of state have to deliver services. They will pay the brunt of it. They would have to pay extra and additional costs. Then regarding the balance of convenience, there's 2 points that I make, and that it's the same scenario. If the relief is granted, the effect of, if the relief is granted and the court finds the regulations to be invalid, the regulations implementations are merely postponed. If the relief is not granted, the harm continues to be present and happen and take place. I've dealt with non-joinder in glancingly. If I may just again, the aim of the application is to suspend the implementation of the regulations and the promulgation. So it's aimed at the bigger picture. In any event, the first respondent does not show that the organs of state and the interim would suffer any prejudice. I've dealt with the test as it is contained in APSA versus Nodia and Judicial Service Commission versus Cape Bar Council. In both those instances, actual prejudice has to be alleged, and I say the onus would be on the first respondent in that regard. I just want to take one step back in relation to the harm. I think I've made all the arguments in relation to the harm. Is there anything else that the court would like me to address?
Does that conclude your presentation, Mr. Van Zyl?
That concludes it for now. My please.
Thank you. Mr. Manager.
Acting DCJ, thank you very much. I hope to be brief The first point I want to address is that from the debates between council and the bench, it's become crystal clear that the categories of preference, which may be based on previous disadvantage, are permitted by section 2172A and B of the Constitution. Secondly, that section 2D of the Framework Act permit organs of state in the determination of their preferential procurement policy to adopt such categories of preference. That is not inconsistent with section 2 of the Framework Act. And thirdly, that the categories of preference can permissibly target specific groups within the previously disadvantaged group. And we have referred in that regard to the judgment of Barnard, where we refer to the majority judgment as well as the judgment of Justices Cameron, Froneman, and Majid, which makes it clear that our Constitution permits such the targeting of restitutionary measures against those categories of people. And the suggestion that it is unconstitutional to do so because our Constitution is based on non-racialism is to ignore the fact that the pernicious effects of apartheid, which are referred to in Viking, were based specifically on race. And as the minority judgment says in Barnard, you've got to reverse that disadvantage. You have to reverse it based on race, fire with fire, but with a long-term objective of achieving an equal society. But that unless you do so, you're not going to achieve that equal society. The second point we make is what the minister does is simply to, in the regulations, identify those goals which organs of state may incorporate in determining their preferential procurement policy. He does not dictate to those organs of state. He leaves them with their discretion and does not provide a closed list because the regulations cannot trump the Framework Act. So to the extent that section 2D of the Framework Act does not provide an exhaustive list, the regulations cannot do so. So the space for organs of state to identify additional goals for preference remains. I want to deal in relation to the actual categories of preference in the pre-qualification criteria with the submission that has been repeatedly made, first by the amicus rule of law, that what the regulations do is to create set-asides. Without debating whether set-asides are permissible under section 2172, simply to point out that it is wrong that regulation 4 creates set-asides, and I will go in a minute to the actual provisions. And secondly, also to counter the lament which Fidelity repeated so many times that the regulations have the effect of excluding it. The regulations don't do that at all. And here, if I can ask, when the court looks at the regulations, to look at page 34 of volume 1, where the pre-qualification criteria is identified, the court will find the wording which is as follows. If an organ of state decides to apply pre-qualifying criteria to advance certain designated groups, that organ of state must advertise the tender with a specific tendering condition that only one or more of the following tenderers may respond. So it's one or more, is discretionary, and is done openly in the sense that it's announced in advance in the tendering document. But the important thing is that category A, 41A says, a tenderer having a stipulated minimum BBBEE status level of contributor. Now, that leaves it to the organ of state to determine whether that level will be 51%, will be 60%, or 100%. So if an organ of state determines that it will be 51%, then Fidelity is not excluded from competing, even when the pre-qualification criteria are applied. That's the first. The second under B is that EMEs or QSEs are not based on race. It is small and medium enterprises who may tender. And C, you will see, justices, that is the tender, is the subcontracting condition. It is where any tenderer tenders, but there is a requirement that you shall subcontract a minimum of 30% of your contract if it is over 30 million rand to any one of these entities. Now, that is not precluding large white companies from tendering. They can tender subject to a condition agreeing to subcontract to the categories under Roman 1 to Roman 8. So the likes of Fidelity are not excluded by this provision. The likes of big companies that rule of law says we must take as an assumption that they are going to give good pricing and they are efficient, which again is a submission made with no factual basis. It is simply the premise from which discrimination proceeds, that certain people are likely to provide better pricing and are likely to be more efficient. But the point is that C doesn't preclude them from tendering. They tender, but subject to the subcontracting requirement. So if one looks at the pre-qualification criteria properly, it is wrong to suggest that there are set-asides, firstly, but secondly, that large white-owned companies are ipso facto excluded, even if the discretion were to be exercised to allow for pre-qualification. They can still tender under C, and they can tender under A, depending on their level of BEE, because some of them might have very high levels of BEE, those would still be able to tender. And fourthly, what has become clear, and we submit quite correctly, is that in the analysis of section 217, it must be understood that section 2172 deals with preference, but once you have identified your categories of preference, when you implement the categories, that policy, you still have to comply with 2171 in the sense that it must be done transparently, fairly, openly, and competitively and cost effectively. And all of those categories that we are mentioned in 4 are all rationally related to the purpose of advancing the objectives of section 2172 and therefore are consistent with the Constitution. Our learned friend for the respondent suggested that you could only find that pre-qualification criteria of this kind is permissible if you had a clear wording as in the BBBE Act. And the response, the question put up by the court was right, that, but you also have to interpret the Framework Act contextually, purposively, in line with the Constitution, and we submit that that interpretation would still result in that organs of state, as part of their policy, can adopt this pre-qualification criteria to advance the purposes of 2172. But what the reference to the BBBE Act undermined for purposes of the respondent's argument is that, in fact, pre-qualification criteria are not ipso facto unconstitutional. And that's why you find them in the BBBE Act. And in one of the judgments, which for now I can't recall, the former DCJ, Justice Museneka, said the PPPFA, the Framework Act, and the BBBE Act, and there I think the case was dealing with the MPRDA, form an interpretive grid when one is looking at empowerment, economic transformation. And here, even the SCA accepts that one must understand that the BBBE Act is part of the legislative framework that is there to advance economic transformation in line with 217. So the reference that our learned friend made to the BBBE Act, in fact, undermines the argument which he says, well, pre-qualification criteria is inconsistent with section 217. It is not. It is perfectly consistent and advances those provisions, those purposes of that section, of that act. And so ultimately, once the court finds that the pre-qualification criteria is permissible under 2172 and 3, and is permissible under the Framework Act, then the regulations cannot be inconsistent with the Constitution and the Framework Act. And the judgment of the SCA was wrong to find that at the level of determining the policy, there is inconsistency with 2171 because that ignores the harmonious interpretation that one must bring to bear in dealing with 217 as a whole. So we submit that both the contentions for the respondent and the rule of law fail to undermine the appeal that the minister has brought. And for that reason, the leave to appeal should be granted and the appeal upheld. In relation to fidelity, fidelity just fails to get out of the starting blocks, first on non-joinder, because it says you must order organs of state to stop implementing the regulations, but those organs of state are not parties. That's the first. The second is, there's no answer to why they couldn't go to the Supreme Court of Appeal under Section 18.3 if they wanted enforcement. And their lament is, well, even if we had succeeded in the SCA, we still have difficulty because the SCA suspended the declaration of invalidity. But of course, they had another remedy, and that was to intervene for the purpose of cross-appealing against the order of the SCA suspending the declaration of invalidity. They've done none of those, and with respect, they cannot succeed. But more importantly, on the interim interdict, Mr. Stubbs correctly submitted to the court that interim interdicts are a matter of discretion for the court, even where the requirements are met. Here, the requirements are not met, but even then, because granting them the order they seek would leave a lacuna. My learned friend says you go back to 2011, you go back to the regulations that pre-existed, the 2017 regulations, but you can't go back because those regulations have been repealed and replaced by the 2017 regulations. So what you will have is you will have a lacuna where issues such as functionality is not regulated, issues of how you deal with where there are tenderers who score equal points. You can't regulate for that because all of those things are regulated only in the regulations and not in the Act. So fidelity with respect just doesn't get off the starting blocks to try to get direct access, because you can't give direct access where the party has no case at all. It wouldn't be in the interest of justice. So we submit that the fidelity application should be dismissed, and that must be dismissed with costs. BioWatch doesn't shield them. They're coming here to protect their commercial interests. They want an interdict, and they should pay the cost of the minister, including the cost of 2 counsel. So we submit in conclusion, leave to appeal should be granted, the appeal upheld, and the fidelity application dismissed with costs, including the cost of 2 counsel. Those are our submissions, Acting DCJ.
Thank you, Mr. Maineche. Judgment is reserved and the court is adjourned.
Thank you for the indulgence, Justices.
Today's proceedings have concluded. The host will now terminate the meeting.